Greetings, 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 greetings. It is I, your king, King Clifford Jefferson, Senator Godfrey the Fifth Caravan Jew, son of folk, ruler of Jerusalem. I am the reincarnation of King Edgar the Peaceful, which we know here at the English Third Temple Church of England as Jesus Christ, or better known as the King of Peace. It is December 1st, 2023, which in the birth year will be 2973. Once again, I'm here on behalf of my English ancestors, here to inform you of your illustrious history that you have forgotten. I would give honor to all those who have gone before me, as well as all those who are here with me, and all those who will come after me, to understand how important it is to understand who you are in this present day and time. I give honor to my moderator, Archbishop Alabama from the House of Belmont. I give honor to my queen, which was the soul, giving me the ability to be able to go into the person that I am. It's very important that you understand what it is that I'm giving to you, because this is your earthly salvation, in which your listening or observation or your review of what I'm speaking to you, your earthly salvation depends on it. All right. So without further ado, let's get started. This is a part two of the lecture I did, Grand Sheik Tarik Bay and Dr. G, about the mind on the Anglo-Saxon people. All right. The video I did, what was it, about 13 days ago. His video had about 14,000 views, 64 comments, all right, and 1,000 thumbs up, all right, for those who watched this lecture. And in this lecture, Tarik goes on to say that the Anglo-Saxon or the English people or the people from England or Albion are cave people or troglodytes, which I prove historically, lawfully, statutorily, constitutionally, as well as um, just common sense, that he's terribly wrong. All right. So all those who are viewing this lecture, I suggest you go back and watch that lecture done by Grand Sheik, Tarik Bay, and Dr. G, the continual preparation of the miseducation of the Negro. All right. The miseducation of the Negro. We know Negroes are blacks are colors, which does not denote to any type of nation, nationality, country, territorial whatsoever. All right. So uh, everything that Todd said in that video about the English people is totally in violation, and we find it here at the English Third Temple Church as defamation of who we are as English people. So watch that video that I did on Tarik Bay. The video was done. It's called Tarik Stop Teaching Lies. Tarik Bay and Dr. G Stop Teaching Lies about the English people of Albion. Once again, Tarik and Dr. G stop teaching lies about the English people of Albion, because you're saying the English people, which we are of that nation, are not people who descended from caves. Nor are we known as troglodytes. All right. Nor are we known as white people or pale people or Caucasians. All right. These terms are wrong. All right. Nor are we descendants of those who were under the authority of those who deemed themselves as monarchs of England, known as the de facto monarchs under the House of Stuart. All right. They are not our descendants. All right. We might have their last names, but they are not our descendants based off what we call primogeniture, birthright. All right. Because we know that the English, Scottish, and every other nation on this planet has their own government. All right. They have their own body of politics. All right. So now I'm going to play the same clip in which Todd says that the English people or the Anglo-Saxons or those who were from Albion were cavemen or troglodytes. All right. And we know that the Scottish kings who were sitting on the English throne as a result of the union of the crowns, the Union of 1707, as well as all that was promulgated here under the guise of those de facto monarchs under the House of Stuart. He goes on to say further on in the lecture he did that the Nefertiti, uh, uh, the Scottish heirs and descendants were descendants of Nefertiti who were Moors. Okay, this he's going to say this. He's also going to say that the English and Scottish people are descendants of Moors, and he said that Noble Ali went to the king, spoke to the Queen of England about the inheritance or the estate that was supposed to be freed and released to them by way of conversion or remandment of the state. All right, these words come right out of his mouth. All right, but has not proven one concrete concrete proof to validate any type of inheritance in regards to some type of estate here in what we now deem North America. All right. So without further ado, once again, he's one of the most influential and misguided teachers that I know. One of the most influential but misguided teachers that we have out there today. All right. So if this is the example of the one that sets the standard, then I feel sorry for all those who claim to be under some other guideship for a lack of information. All right. So let's go right to the record. All right. I'm not slandering the man. You know what I'm saying? I'm not talking about him. But once again, he's the most informal informative teacher that in lieu of what we call de facto under the assumption of being concrete information. It's not de jure, right? And that's what I come to prove. Without further ado, let's get started. We're going to touch a little bit on citizenship today, uh, nationality, contrast to naturalization, which is the type of citizenship that was established here in North America, which was based off foreigners being colonizing this territory, now known as North America, which was affiliated with what we call the British Empire, which was succeeded, which was uh, which was preceded by the English Empire. All right. So please, please pay very close attention by what's being said by Tarik. It starts at a minute and 16, 1 hour, what is it? 1:16:08. All right. And we're going to take it to 1:30. So from hour and 16 minutes to an hour and 30 minutes, which is roughly a couple minutes. All right. So let's go to it. "Quote unquote mixing pot. Those are not circumstantial statements. Mixing pot. They'll say melting pot. That comes from the same thing, but I'm telling you what the original mixing pot. And then they'll say they'll do it politically. They'll say melting pot. No, great mixing pot. So what's that deals with Yakubian experiments at Mexico? And then when you see after the Second World War, just like many of you who know the real politics know that Adolf Hitler didn't die in Germany. He died in Argentina in around 1974 in that era. And what do they call it? Patagonia. So I'm throwing things out there for your research so that you're not following the party line of the hybrids who are desperately trying to maintain power, because now the world is on them. So things will be changing very quickly. And for those of you who have a little bit of knowledge about the social engineering are less distracted, I repeat, less distracted and less apt to be confused about what's really happening. Because remember, as soon as you get into what you call
knowledge of the order of the Great Seal, they will start striking. This is why sometimes, I know it's frustrating for some of you, but some of you know that if we say certain things, they will strike us down. But we're giving you keys that if you do a little research, you'll be surprised of what's available to you that you never paid attention to.
But there is a need, and I keep asking this because those of us who do know also want to know how we can sidestep what the onslaught is coming, because here we are in this, but not of this.
Mm-hmm. But you need to know how now.
So they're trying to sidestep what's coming, because under the presumption of citizenship, the presumption is that you are a citizen, all right? But they don't want to be citizens. They don't want to be classified as the citizens under the definition or term or the meaning of the statute of citizenship as defined by the Naturalization Act of 1790, which only denoted to those who made up that political society, which was none other than free white persons. All right. So now the question becomes, if the federal government only included those who made up that federal government, going back to the Articles of Confederation, which was classified as free white person, which had nothing to do with genealogy or ethnicity as conferred or confirmed in Ray versus Hassan, which we'll touch on in a second, then what is that to say about the states and their citizens, or what was the status of the citizens of the states? Because it was no different than the status of citizens of the Articles of Confederation who make up the United States, all right, which still were classified under that one term, free white person, all right, which excluded all others. Everybody else got included with the coming of the 13th and the 14th Amendment, which are defined as naturalized citizens under the guiseship or the guise of nationals. All right? You're a naturalized citizen. You're not a national because it has nothing to do with genealogy or ethnicity, because the term American deals with everything that denotes to an oath of allegiance, i.e. a pledge, contrast to the political society. All right? The political society or the nation that makes up the people, because you are a foreigner coming to that nation asking for the right to be domiciled. Very important.
We need to know how that translates into the civil order. You know, a lot of
but that's important with nation.
Yeah.
We're not a nation.
We are.
I mean, we are, but we so.
She said we're not a nation, but we are.
I've worked at
One second. Apologize for that. She said we're not a nation, but we are. Let me go back to where we were.
I repeat, less distracted and less apt to be confused about what's really happening. Because remember, as soon as you get into what you call reason, he died in Argentina in around, I think, around 1974 in that era. And what do they call it? Patagonia. So I'm throwing things out there for your research, so that you're not following the party line of the hybrids who are desperately trying to maintain power, because now the world is on them. So things will be changing very quickly. And for those of you who have a little bit of knowledge about the social engineering, are less distracted, I repeat, less distracted and less apt to be confused about what's really happening. But remember, as soon as you get into what you call knowledge of the order of the Great Seal, they will start striking. This is why sometimes, I know it's frustrating for some of you, but some of you know that if we say certain things, they will strike the channel. But we're giving you keys that if you do a little research, you'll be surprised of what's available to you that you never paid attention to.
But there is a need, and I keep asking this because those of us who do know also want to know how we can sidestep what the onslaught that's coming, because here we are in this, but not of this.
Mm-hmm.
You see me?
But you need to know how. Now we need to know how that translates into the civil order. You know, a lot of.
But that's important with nation.
Yeah.
We're not a nation.
We are.
I mean, we are, but we're so fractured. We don't even know.
That's called schism.
Yeah.
No.
We can't stand up and say, no, we on this side, not that. We're amalgamated.
You need to really get the point. Now, what have we always talked about, Dr. B? They need to understand and understand. When we're saying, and we've done over the years, we've gone over and over. You're talking.
Pay attention, y'all. Pay attention.
Not distance. Because the people aren't taught political geography or anthropology. They have been trained in their compressed perspective that foreign means geographical distance only. No, it means jurisdiction. It also means state and state of mind.
Or object. If I'm thinking about, foreign, if splitter goes into my eye, that's foreign. That's foreign. Yeah, it doesn't belong there.
A corrupt thought.
It's foreign.
All right. Okay. De facto.
Foreign.
See, color.
Foreign.
See, now, by people not knowing orthology and etymology, which is, again, why we even went in this book, just to give a snippet of 8th grade erudition. And also you deal with the alteration into the education system 1902, the part it played. Then when you go into the conquest of Nefertiti's daughters, right? So most of these people don't know that Scotland in that area is Nefertiti's daughters' territory. So in the 1800s, mid 1800s, when they took over England, Scotland, this is why most of the people don't know that the Picts and the Doves are Moors.
But they show us the movie.
But our people think it's like a movie.
Yeah, The Last King of Scotland.
Because that's, all right, now you're talking Nefertiti's bloodline. See, but when they tell you about Nefertiti, right, what do the people keep thinking? They keep thinking Hikuta on the northern coast of Alexum or Africa, right? So their mind doesn't run to the peninsula, does it? But what is the real history before socialization? So they don't know that Iberia, again, Dr. G, when they take people that come around the world and people that belong in the lodges, when they take them to that last lodge that George Washington shut down on.
So you heard him. The Nefertiti were related to the Scottish kings. All right? Nefertiti were related to the Scottish kings, but it's the Scottish kings who enslaved the so-called people identified now as Negro, Black, Colored, Ethiopian, going back to the triangle slave trade, or what we call the Atlantic slave trade, going back to the Iberian Peninsula. All right? He ain't telling you that, though. He's not telling you that, though. That slave trade was done by Scottish kings, Scottish monarchs. All right, from King James going all the way back to Kenneth Alpine. All right, you must understand the history and not just be talking about something you don't know. He's going to go further on to talk about the inheritance that so-called belongs to the Moor. Noble Ali spoke to the Queen of England. All right, and the Queen of England at that time, if Noble Ali was supposed to have spoke to her, was a German king. All right, not an English king. So if it was a German king overseeing the property of the English king, then that means that that German king under the Kingdom of England was de facto. All right, was de facto. Let's continue.
Growing Jupiter, right? They take them to the ionic room. And the Iberia, even so, when the people are looking at Iberia, they're not thinking in their mind Moorish, are they? Now, this is back to people not knowing the different attributes and names that belong to them that they think they have no association to. So the advantage of those who are adeptus, they know that our people are hidden in history because they don't know themselves, not because they're actually buried in a hole and branded with a coat of many colors. So they think that human beings are different colors.
So they don't know the story of Joseph.
It's to make them non-descendable as law.
But these stories are depictions.
Legal fictions.
What's going on?
Actuality. Exactly.
Because like I told you, I for a long time, all my degrees in, theology, I kept wondering, and at the time I wasn't knowledgeable about not being black. Well, where do black folks come in? Where do we come from? Where do we, where does America, it never dawned on me, and never taught,
Yes.
to how to interject. You were just supposed to believe in this stuff.
Now, and then look at here. Here we go again, right? Oxford Dictionary, right? Right? So now let's go to the fourth style.
The same book, he said in the same video that the English people were, or the people from England or Albion were troglodytes, which were people who came out the caves. All right? We know that the Scottish people were subjects of England as a result of the Scottish independence in 1295. Okay? 1295, Scottish got their independence from the Angevin king or Plantagenet king, Edward I. All right? Edward I, son of Henry III. He ain't telling you that, though, because he don't know that history.
Eighth grade principle, 1800s, right? So now here we go, look. Compound words, right? Now, archaic, which means old, right?
Right.
So it's noun, right?
Right.
But it's a compound word,
Yeah, black.
right? And also, in a small case, right? Black, right?
Right.
Uppercase, more.
Right.
So one who can read know that this adjective is not the noun.
Right.
The noun is here, but it's a compound word. And so it says what? From black, all even case letters, A plus, which means added, more, capital M-O-O-R, noun. Right after that, see, adjective, noun. Adjective, noun. Put together, plus.
Yeah.
Connecting, A, unexplained, which means they're not explaining it to you.
Because they don't know.
Nor you explain it. Nor you explain
They're
it.
not explaining it, but they're putting it here. A black African, a very dark-skinned person, right?
Now he's reading from an Oxford dictionary in regards to the characteristics of a depiction of a person. All right? Which at that time, which we make reference to Dred Scott, was a slave and was considered property at this time in era. Parts of not at that time in era because they were free, all right, from that, or emancipated from that type of bondage. All right, but the bondage which he was emancipated from goes back to the time of the Scottish kings, which he's claiming that the Moors were descendants of. I better listen.
So they're telling
A very dark skinned person, but I see very dark skin in so-called Indians, I was in the Indian store, so-called.
all right. So
today,
the people
and some
think,
of them are, yeah. So
the people think that the adjective is the identity.
right.
More's the identity.
It's a description.
Black is the tag, is the adjective attached to it. It's to hide the history. But it's there. The history of who? The real Africans. And all, and not some, all of the dark skinned people. Not some, all. Now, under a challenge in sociology, as the people start waking up around the world, right? Now you understand what Duarte was saying in the Philippines?
Y'all listen.
Now you see, years ago when Bill Clinton was speaking before, I think the United Nations, and they introduced him. They say, and now the American president, and I think was Vicente Fox, I think, was president for the United States of Mexico, I think, at that time, and he objected. He says he is not the American president. I'm also the American president. America's a continent. We have a lot of Americans here. He's the president of the American Corporation, United States of America. And you know how much they didn't blow that up in the mainstream news? But that was said right on the core of the United Nations when they introduced Bill Clinton as, quote unquote, the American president, because he ain't American. And see, more and more.
What is the difference between American corporation and America? They're one and the same. All right. The American corporation was a corporation set up by the charter given by the grantor. All right. This is why you must understand the Constitution, and the intent of the Constitution what grants the authority for the government to be granted as from the get-go, going all the way back to the Articles of Confederation, which was a weak government. The only government power that they had was the power to belong and rightfully belong to the king and parliament, which the colonies surrendered under the Articles of Confederation. All right.
The Americans, and this is where you have Organization of American States. This is the real Americans, and you, in order to have a voice, and they're always suppressing it. Why? Because they've been falsely promoting their private corporation as a country, and they've been getting that off. That's why Duarte said what he said relative to the Philippines. He says they call us Filipinos, but we're really Moors. And so these things have to be corrected by the nomenclature or the nom de guerre were put in place, known as the brand system, by the hybrid Europeans who conquered the Western Hemisphere to bring the people under what is known as wardship tenures. Write that down, you all. WARDSHIP tenures. That's a military operation. People are held to wardship, and this is where the Negro and black tag comes in, and color tag comes in, which are schism operations, military operations, to create schism, or what you call divide and conquer, among the true Americans. These is where these terms have taken root in the social structure.
Okay, so we're going to use that as a navigation tool to go to bring clarity to what he's talking about. All right, because he said that they are Americans contract to the American corporation, and we know that America was under the British Empire. All right, called British America, which is authority was what we call king and parliament. And king and parliament goes all the way back to the king and parliament, or what we call the Parliament of England. And we know England, Ireland, and Scotland had their own separate parliament. So when you're talking about America and then he's going to talk about Native Americans as well, and he's going out his mouth are going to say that they didn't have a right to the land or were not originally indigenous to the land; they were just occupied of the land. So, in that respect, he's got to prove that Moors have a more indigenous claim than the Native Americans, and he has not provided one fact or proof to support that claim that the Moorish Americans have more rights to land than Native Americans. Because in the eyes of law, y'all both occupants on soil that don't belong to you because it was inside of left in what we call a trust, which Todd's going to talk about, right? That the King of England was in charge of, i.e., represented by what we call the crown, because the King of England represents the crown, i.e., a corporation soul. He's going to say it.
This is one of the major arguments that Noble Raleigh made when they spoke to the Queen of England relative to their obligation to the Constitution and treaties, and that these were all what? Brands, and is not the names of these people.
Okay. So you heard it. He said Noble Raleigh spoke to the Queen of England. Whoever he spoke to was not the Queen of England, because the true Queen of England goes back to the time of our ancestors. All right, as we because really the Queen of England is just another position referring to a woman sitting in the seat. All right, but that's matrilineal contrast to patrilineal. All right, matrilineal contrast to patrilineal. So the Queen of England had no authority to pass on the state because in an agnatic succession, it was left up to a male heir to inherit the state. All right. So once again, Charles does not have a clue of what he's talking about. Let's verify it.
Nationalization that he set up for the restoration of the heirs of the estate.
Now, she just got finished saying that, and he confirmed that they're not a nation, but an idea of a nation, but not on the books as a nation. So what estate can you have as an idea of a nation in reference to a state, i.e. meaning land left over that was under the control of the crown and which Noble Raleigh went to speak on behalf of the people of the Moors, which was land that was under the overseership of what we call the crown. And as I add, a de facto monarch at that time, not de jure.
Again, by the Secretary of State for the United States Corporation was set out, although he tried to interfere, tried to interject himself, he was set out when they had that meeting in Havana, Cuba, with Raleigh dealing with the restoration of the estate or the return of the estate. And this is back to even why a lot of these so-called Indian tribal leader guys resist telling the people the truth about that. A lot of this information was supposed to be presented to these people under the rights of indigenous people, and also the advent of decolonization with the U.S. corporation being one or like number one on the list of hybrid Europeans who by international law were supposed to start telling our people this history because they were supposed to start decolonizing. So look up decolonization, and it was supposed to be really instituted in around 1960.
Okay, decolonization. All right, not decolonization means to be removed from that land. All those who colonize the land will have to be removed from that land. All right. So the land was left in what we call a public trust. That's subject to what we call the public trust doctrine. All right. That the United States, the now government that was originated from a weak central government known as the Articles of Confederation that consists of only 13 states, which were originally called colonies, which was still under the authority of the Kingdom of England under de facto monarchs, as Todd just said. going all the way back to not just the monarch or the so-called queen that he said that Noble Ali spoke to, but also the Queen of England, going back to Queen Anne, that was under the Provincial Council sitting here in New Jersey in 1776. All right? Charles has not proven one bit of proof in regards to some inheritance of an estate by some legal instrument in regards to the Moors having a stake in the claim in lieu of a birthright. Because I'm going to show you that the status of those as Moors were still under the same status as those that Negro black cousin Ethiopian over here. All right. As a result of them lacking the understanding of the right of entail estate that was left for English heirs. All right. That was left for English heirs. If nobody spoke to the Queen of England in regards to return of the or remandering of the estate, and we know Noble Ali said that the Europeans gonna have to pay back in compound interest for what they did to our ancestors at the time of slavery. He also said, in some of the oral remarks in regard to Noble Ali by some of his predecessors or followers, they said that the European, he said that don't throw away the slave names. But the new Europeans gonna have to pay back compound interest for those names that we bore upon because those names belong to us, which they stole. They stole these names. You're not Moors or Ottoman Turks. You are English descendants, as Todd just said. The corruption of that knowledge of English descendant comes in the time of what we call the War of the Roses. All right, which was between the Yorks and the Lancaster cadet branches of the Plantagenet crown. All right, a rival family feud, which as a result of that rival, the House of Tudors, which was the Lancaster branch, gave birth to the House of Stuart, which uh, um, which well, which benefited off the slave trades because they are the ones who enslaved the original heirs that gave birth to the cadet branches of the Yorks and the Lancasters. Because most of the common recovery practices that were done came under the reign of those French and English kings that were descendants of Edward the First. All right. And we're going to prove that by what we call the Tarik case. The Tarik case was a case that provided for the common recovery to be practiced by what we call power of attorneys, which were left as trustees over the estate that was entailed. All right, which then changed them from entail to fee and simple. All right, to fee and simple. Oh, I'm gonna prove it today, y'all. So put on your thinking caps. Let's close out Tarik and disqualify everything that he just said. All right. Where do you want to go? Let's deal with the sesquiquae, because that's the last video I left off talking about the sesquiquae. All right, that's where I left off talking about. Because it all involves the property. And we know the property refers to the land because the land is real estate, i.e., real wealth, versus or contrast to what we call paper wealth. All right. Sesquiquae, make sure you see this. I'll be sticking and moving because I got a lot to cover. Sesquiquae literally means the person for whose use the benefit of freedment was made. In modern terms, it corresponds to a beneficiary. All right. So a sesquiquae or freedment was a trust for which was left for a beneficiary. All right. Which means that it's not fee and simple, it's entail. 1 second, y'all. Okay. We're talking about the cess which is a trust established entail for a beneficiary, which is based off primogeniture, which means firstborn. All right, you see it right there. Primogeniture, firstborn legitimate child to inherit parents' entire or main estate. All right. What was it at? Right here. Real quick. We talked about this yesterday, so I don't want to stay on this. Besides obvious limitations placed on a cess by the statute of mortmain, the statute of uses, and the statute of will, its legality was shaped indirectly by provisions within the Magna Carta and Queen Imperatrice. Queen Imperatrice was established by Edward I, son of Henry III of the Plantagenet crown. Statutes of mortmain, the statute of uses, were created by Henry VIII of the from the Lancaster cadet branch of the Plantagenet crown, which was officially now a part of what we call the House of Tudors, established by Henry VII. All right, very important to understand these keys that I'm giving to you. All right. All right. So the cess-tu-quae was a trust set up for a beneficiary, i.e., English heirs, because as it said, it was established by Edward I. Edward I. All right. Edward I, Queen Imperatrice. Let's put that. Queen Imperatrice is a status passed by the Parliament of England in 1290 during the reign of Edward I. Remember, the Scottish kings, all right, didn't get their independence until 1295, all right, under what we call Scots independence under this king, Edward I, all right. They also had the Order of Alliance, which Scottish kings made with the Frankish kings, which were warm with the English kings, all right. It says here, Edward I was Queen Imperatrice was a statute passed by Edward I that prevented tenants from alienating the lands to others by what we call subfeudation. Instead, required all tenants who wish to alienate their land to do so by subfeudation. The statute, along with its companion core warrant to order the show cause, also passed 1290, was intended to remedy land ownership disputes and consequent financial difficulties that have resulted from decline to traditional feudal system in England during the Middle Ages. All right. We must understand it. This goes into what we call revenue. Revenue is a sign of tax or impulses that creates revenue and what we call tariffs. All right. Tariffs. The colonies were subject to tariffs established by the monarchs of England. We're going to discuss that today because I have a case law that deals with that. All right. Which let's go to it right now. All right. Before that, let's deal with this. Tarik case. Tarik case is a name given to an English legal case heard in the Court of Common Pleas, with decisions being handed down in 1465 and 1472. The case was long thought to have established the operation of the common recovery a collusive legal procedure that was until finally abolished in 1833, an important element of English law of real property by means of the complex legal fiction. A recovery converted a freehold or copyhold, freehold copyhold, or it's called fee and simple, all right? Property held in fee-tail or entail, which could not be freely sold or disposed of into any estate in fee and simple, which could be disposed without restrictions, all right? This statute was passed by Edward IV, all right? Edward IV was of the House of York, which was warm with the House of Lancasters, which were both cadet branches of the Plantagenet crown. All right, we're going to see this reference in what we call Jones versus Freedom. All right, Jones versus Freedom. All right, we talked about that in my last podcast. We'll go to it. We'll reference it real quickly in a second. Keywords: intel estates, fee-tail, common recovery, barring the intel, or converted to normal estates of fee and simple. All right. Principles of barring intel. Intel has been established by the Statute of Westminster of 1285 by Edward I. The statute included clauses known by the title of the donus conditionalibus. All right. Everybody see that? Concerning the conditions of the gifts, which enacted that in grants of land to a man and the heirs of his body, the will of the donor as expressed in the grant should be strictly followed. Prior to this time, judges had held that if an estate was granted to a man and the heirs of his body, and the heirs were subsequently born, he had a title to the land in fee and simple and could do as he wished with it, including selling it, even if this was contrary to the original donor's intent. All right, the original donor's intent was what we call fee and tail under what we call the donus conditionalibus. Let's see this. Also passed by Edward I. All right, Edward I. And once again, Edward I was a Plantagenet king who was warned against the Scottish kings, which made them subject to the English kings by way of what we call the Scottish independence of 1295. All right. So Scottish kings joined with the Frankish kings as a result of the conflict between the Frankish and Scottish conflict with the English kings. All right. It goes all the way back to the kings of Wessex. All right. Goes all the way back to the kings of Wessex. So the donus conditionalibus is originated by the law of entail forbidding a landowner to sell his land except to his heirs. All right? You cannot sell your land except to your heirs. All right? So let's go back to sesquique. Sesquique, which is right here, was a trust set by a fief given to a trustees and protected by laws passed by the statutes of the Plantagenet King Edward I. All right, which were carried out over into what we call the House of Tudors by Henry VII and Henry VIII. Where was I at? Okay. Besides the obvious limitation placed on the sesquique by the statutes of mortmain, because Edward I deemed all property of the church inalienable. All right. So that means that it became entail. All right. You couldn't separate it from the church. All right. Because the church held the property as entail, and it was part of what we call the king's jure regalia, as corporations so ruling under what we call the king's royal prerogatives. All right. So the statutes of mortmain were passed by Edward I, and then it was qualified by the statute of uses and the statutes of wills as determined by Henry VIII of the House of Lancaster, who was the king of the what we call the House of York. I mean, the House of Tudors. All right, which put everything in what we call the Sesquique, a Sesquique trust. All right, as instructed by the Magna Carta under Queen of Praetors, created by Edward I. Henry VII, as you see here, and Henry VIII. As a result of the English Reformation that fell under what we call the English Civil War through the War of the Three Kingdoms, with England, Ireland, and Scotland, Henry VIII put everything that belongs to the English church in a trust to separate the property from the English church from that of the Roman Catholic Church, which is under the auspices of the Archbishop of Diocese of the Roman Catholic Church, such as St. Augustine of Canterbury, which had all the Anglo-Saxons converted to Christianity in 497 through the English Reformation under what they call, parts of the Gregorian Reformation. All right, we talked about it already, so I'm not going to go through it right now. Let's see. All right, so let's get into this. So we know the Talcum case, which was a case that allowed for the changing from an intel state, which couldn't be so pursuant to the Donovan Conditional Bush, as also as provided by the court warrantor, which was a royal prerogative of the king to bring in the questions when such cases arises. It says right here that under common recovery, that intel estates were able to be turned into what we call fee and simple estates by way of common recovery, as you can see here. Principles for borrowing intel estates were denoted as what we call common recovery. Everybody see that? Common recovery is the only way to borrow intel estates, and that's done by what we call power of attorneys. Power of attorneys. Let's go here. So what is common recovery? We're talking about the estate that Taj was talking about, because he said that Noble Ali went to the Queen of England to release the estate that she was overseeing in lieu of the office that the Queen of England hold as corporation sole. But of course, the corporation sole was not the office that queen was holding. The office she was holding was part of a corporate aggregate office. Why? Because she wasn't seen as a natural person. Why? Because they were all subject to the Roman Catholic Church. All right. This is why everything was put in a trust, which when under the Treaty of Paris of 1783, all that was under the auspices or under the trust under the crown. The United States government became the overseers of that trust, which now became abandoned, vacant property. All right. Why? Because there were no heirs to claim the property, which left it up to the king to regain that property. All right. Under what we call what it says, operation of law, because we know that property in lieu of inheritance, in lieu of intel, transferred by way of what we call operation of law, by way of disposition. We see here, common recovery was a legal proceeding in England that enabled lawyers to convert a intel estate, a form of land ownership also called fee-tail, into absolute ownership. Fee simple. All right. So they went from fee-tail to fee simple, and fee simple is what the United States claim to own property, and that's under what they call prescription of sovereignty. Okay. prescription of sovereignty under in law what we call easement over the claim of what we call sovereignty. They don't have any sovereignty. I'm going to prove it. This was accomplished through the use of series of collusive legal proceedings, some parts of which were fictional and others unenforceable, and therefore null and void. All right? We're going to see that in what we call Jones versus Freeman. It was devised and perfected by lawyers in the second half of the 15th century. A 1472 case known as the Tarik case increased in its popularity, passed by Edward IV. All right? Edward IV was of the cadet branch of the Plantagenet crown, which was a part of what we call the House of York, which is also mentioned in Jones versus Freeman. All right? Which we go to in a second. So they changed entail estate to a fee and simple estate by way of what we call a common recovery process done by what we call private attorneys. Private attorneys. All right? Any deed that was written up in regards to some type of interest in some property was written by an attorney. All right? These are called your brokers. All right? The brokers and his associates. Let's get to this. So common recovery was the way to change entail estates from entail to fee and simple, going all the way back to the Tarik case. And we know the Tarik case violates the laws passed by statutes of Edward I, which the donors condition of bus, which means that you cannot sell an entail estate, nor can you alienate an entail estate by way of what we call subinfeudation. And common recovery is a process of subinfeudation, alienating lands. All right? Alienating lands. Dred Scott's going to qualify this. All right? The Dred Scott case is going to qualify that. Dred Scott case is one of the most profound cases that the English people should understand is the remedy for their redemption and the return of their property as established in that case. All right? I'm going to show you that case shows you that the return of your property is within reach. Check it out. Let's prove it by statute first, because they stole it by common recovery. Now I'm going to show you how the legislation of the common law of England by the King and Parliament that was here in New Jersey preserved your right to entail estate. Why? Because they abolished common recovery. Let's see. These are what I'm using in regards to our claims that are right now up in the district court, i.e. circuit court, on the English people behalf. Right? Nobody else. No one else has an inheritance in the land or property that was associated with what we call the public trust, because Dred Scott case makes reference to the public trust. It didn't belong to Native Americans. It didn't belong to free white persons. It didn't belong to the Scottish kings. It didn't belong to none of them. It belonged to the English heirs. All right? Which was stolen at the time of the Norman conquest. It says it right there in the Dred Scott case. Yes, it mentions the Norman conquest. All right? When they invaded England. And we know England was right here. Let's prove it. It's one of probably the best lectures I ever did. This one right here. New Jersey revised statute in regards to possession. And we know possession means ownership. All right? Title 46 deals with :ownership. 46:3-10, fines and common recoveries are abolished. So everything that was done in the 14th century, established by the Tarik case, is abolished in this modern day, present day, under the common law of England. From and after June 12, 1795, no fine or common recovery that has been or shall be entered, made, or has suffered in any court of record of this state shall operate or be construed to be a conveyance or assurance of a real estate, or in any way bar the issue of entail, fetail, or the reversioner or remandering of their lawful claims and entries and uses or customs to the contrary in any wise notwithstanding. That's modern day promulgated legislative statute referring to the common law of England in regards to in the states that's intel, which means that's a lolio. You can't sell it. It's just said it right here. It's abolished. Why? Because 46:3-6 of the same statute says that the land is a lolio. Right? 46:3-5 because it goes into reference to um um what was it called? What is that called? Sister Quay. Right here. Queen Petoris. New Jersey Revised Statute 3-5 make reference to the term Queen Petoris. All right, which was passed by who? Edward I. That's in New Jersey Revised Statute 3-5. Queen Petoris. Right here. By Edward I. You'll find that in New Jersey Revised Statute. That right there. So going back to New Jersey Revised Statute, common recovery was abolished so that no intel claim in lieu of an estate left for heir can be barred in the courts of law in this present day. And lieu of what we call reversion remandering. Why? Because it's allodial. The land is allodial, has always been allodial because it's subject to the statute of motor main. It's a dead pledge. All right? It's a dead pledge. Let's move forward. Where I'm going to go. Let's go right here to Jones versus Freeman. All right? Jones versus Freeman. Because we know that the Tarik case was passed in the 14th century by Edward IV, as it said. Now you see Edward IV here and Jones versus Freeman. And they're talking about de facto and de jure offices. All right? There must be an office. All right? If it's a jure office, then that means there is no interregnum because of the demise of the crown, which means the king never dies, or the Latin term rex nunquam mortier. The king never dies as a result of the conveyance of the transfer of that office to an heir. All right. If there is no heir, then there's an interregnum. This is such the case when we get into the English Civil War with the War of the Three Kings of England, Ireland, and Scotland. As a result of what's transpired between what we call the Plantagenet king, the cadet branches, the House of York, which gave rise to the Union of the Crown in 1503. All right, which resulted of what we call the Treaties of Perpetual Peace of 1503 and 1534 between King James IV, right, and Henry VII, and King James V and Henry VIII of the Lancaster branch. All right, they were preceded by the Treaty of Westminster of what was it, 1467, which was a result of King James III taking the side of Edward IV. All right, King James III taking the side of Edward IV. I'm part of not taking the side of Edward IV, but taking the side of King Henry VII. All right, I mean King Henry VI. King Henry VI succeeded Edward IV of the Plantagenet cadet branch, the House of York. Once again, King Henry VI preceded King Edward IV. All right, and King Edward IV passed the Tarik case for allowing intel states to be turned into fee and simple estates. This is the reason why we fell in lieu of now understanding our vast estate, which was under protection of the crown at all times. All right, here we have it. Jones versus Freeman. Until promulgation of majority opinion, there was no determination that the legislative districts, House and Senate were invalid, and whereas there may be a king, though an usurper upon the throne, nevertheless there must be a throne upon which the king may sit. All right, what's it saying in regards to the king in Parliament, contrast to which was under the fusion of power, contrast to the separation of power that comes into what you call the Articles of Confederation. All right, the Articles of Confederation, which you now call the United States, was based off a separation of power. All right, and the separation of power separated the legislative and the king fusion of government, which now allows the House, the upper house and the lower house, which you call the Senate and what we call the House of Representatives, to fall under the authority of what we call the executive branch, which is a total violation of your Constitution pursuant to Article 1, Article 2, and Article 3. How? Let's see. They're usurpers. In 1461, on the occasion of Edward IV, Parliament declared the previous Henrys of the Lancasters usurpers, but to avoid great public mischief, also declared them kings de facto, and persons were punished and arraigned for treason to Henry IV, not in the aid of the lawful claimant of the crown. All right, all this was a fight over the English crown. Let's go a little further. So there must be an office. There must be a crown. Whether the person sitting in office under the authority of the crown, known as the English throne, was de facto and de jure, it's the same situation here in what we call North America, under this government. The officers who are occupying their tenures are de facto in nature. So therefore, the office is null and void. So office is null and void because it violate the standards that it was based upon. All right, and they gave you an example that in which the office was based upon, in which those officers pledged themselves. Right here. Everybody knows the Marbury versus Madison case. You should familiarize yourself with that case, because this is based off of a writ that was presented to the Supreme Court, which was denied as a result of the overreach of power that was not sanctioned by the Constitution. All right. It says here, it has never been doubted in this country since Marbury versus Madison that an act of the legislative department of government contrary to the Constitution is void and subject to that declaration by the courts. Indeed, it was never doubted prior to Marbury versus Madison that an act of the legislative department of government contrary to the Constitution was void. That matter was previously held by a bunch of cases, including the case, or one of the first cases in New Jersey called Holmes versus Walton. Everyone who's familiar with that case or not familiar with that case, I suggest you look that up. All right. The old courts of appeals under the Articles of Confederation. You hear that? The old courts of appeals under the Articles of Confederation. All right. Confederation laws that assign circuit duties to the judges of the appellate tribunal, the judiciary debates of the Congress of 1802, and the ancient British Presidents of America Law Review, volume 29, page 711, makes reference to the Doomsday Book. And it was recited what power the king has, he has by law. The greatest inheritance that the king has is the law. For if there was no law, there will be no inheritance. Consequently, no king. You hear that? Once again, the greatest inheritance that the king has is the law, for if there was no law, there would be no inheritance. Consequently, no king. All this is left for the judiciary to review. All right, and which we see under the present administration, under the founding of this country, based off those sitting in the judiciary tenure, they ruled that they're not going to question those who put them in their positions. Why? Because that's their God. So of course, the Supreme Court ruled in Marbury versus Madison, and contrary to the writ of mandamus that was petitioned by those sitting in that office. All right, sitting in the office petitioned by the colorableness of the office, but they didn't want to let the cat out the bag. Why? Because they know the color of the office was de facto from the door, contrasted it being de jure. Why? Because it doesn't go back to the origin of what the office was established from in the first place. Where it was established from in the first place, let's see. All in Jones versus Freeman, a 1944 case from Oklahoma. And we know Oklahoma is a territory that was belonged to what we call Native Americans called Indian Territory, which was under the authority of what we call the Kingdom of France. All right. If you go back far enough, you know that the territory known as the Indian Territory was under the authority of the Kingdom of France under the House of Capet from the Capetan dynasty, who was warned with the Plantagenet king, which Edward the First, Edward the Second, Edward the Third, Edward the Fourth, which we're making reference to in this complaint right here, descended down from. Okay. And everything that was used to decide cases in regards to judicial review was based off the Anglo-Saxon trial by jury system. Once again, the Anglo-Saxon trial by jury system, which was adopted in all constitutions as promulgated in the Magna Carta. It should be preserved. How I know it, let's see. Right here. The United States should guarantee to every state in this union a republican form of government and should protect each of them against invasion on the application of the legislature or of the executive when the legislative cannot be convened against domestic violence. Of course, the legislative can't be convened against domestic violence because the domestic violence is being committed by the executive branch. All right, that's where the violence is coming from, the executive branch, as a result of the separation of power from the fusion of power that was inherited in the king and parliament under the royal prerogative, and not under a council under positive law. All right, it says that in all probability, in regards to the present republican form of government being preserved, going all the way back to the time which the Republican form of government was established to protect it from the chaos that's going on in this present administration. It says that in all probability, domestic violence as a result of chaos would ensue if a de jure or de facto legislature could not be convened. Anglo-Saxon civilization afforded a rule of law, Rex non quam mortier, which means the king never dies. And to avoid such chaos and violence, the Constitution was constructed to provide such replication of that which was designed by the law, which created by the Anglo-Saxon system. They ain't even talk about the judiciary. It said the Anglo-Saxon law. All right, they said the Anglo-Saxon law, and no, the law is created by the legislative branch, not the executive branch. If law is created by the executive branch, then there's a violation of the public trust. All right, there's a violation of the public trust. So it said, where do I want to go? Let's go here. Let's go here. The Lemon versus Bedell. Before we go into the case, let's go to Wikipedia. Everybody pull that up. Thank you, Archbishop, for this case. Thank you, Archbishop. All you judges, I don't care what circuit court, what appellate court, what Supreme Court you come from, you better be listening to me. You better be listening to me. All right, because we understand that all land was left in a trust. It's called crown land, and all land is intel, and all land is intel could not be so subjugated under the process of common recovery because we already qualify under Georgia Revised Statute 46:3-10 that no common recovery are allowed. All right, no common recovery is allowed. We know Ward versus Martin versus Waddell, as well as the Johnson versus McIntosh, all cases dealing with the public trust doctrine. Okay, all deal with the public trust doctrine. And the public trust doctrine deals with land held by a trust held by the king, which is substantiated by the state represented by Attorney General and Standard Oil Company, which clearly says that when there is no heirs, all property is streets as a result of interstate to the crown. Okay, and the crown authority is still here because it's the royal prerogative that's perpetual. All right, here in North America. How I know it? We're gonna prove it. All right. We know when land is succeeded, you know what I'm saying, it becomes permanently a part of that which is proceeded to. All right. And this is qualified by what we call treaties. All right. Treaties. All right. We know that you have a whole bunch of treaties, but the one reference to this modern day in regards to the succession of land here in North America goes all the way back to the Treaty of Paris of 1763. All right, when all the territory that was under the Kingdom of France was succeeded to what we call Great Britain. All right, then you got the Treaty of Paris of 1783 when all the territories of Great Britain was succeeded to what we call the United States. And the United States at that time was under the Articles of Confederation. All right, and the Articles of Confederation under the Republic form of government, under the Articles of Confederation, system of government was based off that of the Anglo-Saxon as qualified in Jones versus Freeman. All right. Now we're dealing with DeLima versus Bidwell because it deals with uh, uh, the right of raising revenue for the new nation that was created here by way of the charges given by the monarchs of the British Crown. All right, to the 13 colonies under the Articles of Confederation, which in the modern day it goes or extends back to what we call the New Jersey and New York campaign, as well as the Philadelphia campaign involving the ports of New York and New Jersey. All right, which was affiliated with the Triangle slave trade, or what we call the Atlantic slave trade, going all the way back to the Iberian Peninsula. All right, which Childs was talking about, but does not have a clue because why? The ones who were being enslaved on the Iberian Peninsula was done on behalf of the Moors who were enslaved with the English people at the time, going back to the Plantagenet Wars, not just the Frankish, but the Scottish kings. All right. And as a result of the usurpation as de facto officers under the Treaty of Perpetual Peace 1503 and 1534, on the alliances made with Henry the Scottish King, King James IV, King James V, and Henry the Seventh and Henry VIII, and Henry VII was the founding House of Tudors. They created an alliance as a result of Henry VII's conquest of the English throne by way of the rivalry that was going on between the cadet branches of the Yorks and Lancaster, which was mentioned in Jones versus Freeman case, which Edward IV said all the descendants of the Lancaster branch were what? Usurpers. If they were usurpers, they were de facto officers under a color of title, under color of office. All right? On the color of office. So any contract, any agreement, any engagement that was made under color of office is de facto. Why? And is not valid and void as prescribed under the Articles of Confederation, because under the weak government and central government that the Articles of Confederation had established at that particular time, they could not raise revenue for themselves other than that was based off domestic trade. There was no allowance for international trade or what we call foreign trade. Why? Because foreign trade at that time or international was under the authority that was done by the British Crown. We can get into the what we call it Taxation of the Colonies Act of 1778. Once again, taxation of the colonies of 1778 under King George III as a result of going to what was it? We're gonna talk about right now. All right, let's talk about it right now. Dilemma versus Bedell. This all deals with tariff law. All right, all deals with tariff. Dilemma versus Bedell was one of the group of first insular cases decided by the United States Supreme Court in 1901. Insular cases deal with matters involving islands, which Puerto Rico is an island which was ceded to the United States by way of the Treaty of Paris of Spain. Now we know all the territory that Spain had was ceded to France, and all the territory that Spain ceded to France was ceded to Great Britain in 1763 of the Treaty of Paris. So why would the United States be making another Treaty of Paris with the Puerto Rico? All right, which is the case at hand. Let's deal with it. Let's go to the box. Upon the ratification of the Treaty of Paris, Puerto Rico was not a foreign country for the purpose of tariff laws of the United States, which required payment of duties on goods moving into the United States from foreign countries. All right, once again, the holding in this case in 1901 dealing with the dilemma and the Sugar Import Company against the Port of New York, i.e. Port Authority. All right, Port Authority. It says upon the ratification of the Treaty of Paris, Puerto Rico was not a foreign country as a result of secession to the United States. And we know all territory secession, all territory ceded becomes the property of that the one who owns deed to the land. All right, and we know the United States was successor of the crown. We proved that in the public trust doctrine, which we'll refer to lightly in a second. All right. It says upon the ratification of the Treaty of Paris, Puerto Rico was not a foreign country for the purpose of the tariff laws of the United States, which required payment of duties of goods moving into the United States for a foreign country. First of all, in lieu of the dispute between the company called the Dilemma Sugar Company in New York City in regards to Port of New York City and the Port of New Jersey, let's go back to the origin of tariffs. All right, because tariffs deals with international trade or foreign trade. All right, of imposts, dealing with impost duties, i.e. taxation. All right, so let's get a brief history of the origin of tariffs, where it originated from, which it actually originated from Edward III of the Plantagenet Crown in Great Britain. We ain't concerned about ancient Greece and all that particular time because that's the time of the mind. The records that we're reflecting here in case law refer to the time of the mind, which we call time immemorial. And we know time immemorial, according to law in the courts, goes back to Richard I, son of John, son of Henry II, son of Godfrey, the fifth Count of Anjou, which we are descendants of. Why? Because there is precedence there. All right. And these are all the associates justices that reflected or gave their opinion or statement of reason in this case. So let's go to the case. All right. Dilemma versus Bedell. Everybody pull that up, go to point 132. I'll give you a second. Dilemma versus Bedell, point 132. Now, in this case, Dilemma versus Bedell, the court ruled that the Port Authority could not tax as a result of the succession of Puerto Rico to the United States as a result of the Treaty of Paris. All right, that was the case. That the opinion of the court as a result of the court was not the state or the colony at that particular time prior to this case was not allowed to deal with foreign trade. All right, it was not allowed to deal with foreign trade, whereas under this new administration of government, they are. All right, this is a violation of law. They're going to be in trouble for this. Why? Let me prove it. In the Lemon versus Bedell, first of all, let's prove it first. Let's go to tariff before we deal with that case, because that case involves tariffs, i.e., imposed duties on trade. All right, foreign trade or international trade, which was the case that we see. All right, but let's check out the origin of tariff. All right, and what tariff means. We know the United States passed the Tariff Act of 1789, which was one of the first acts of that Congress to raise revenue. All right, to raise revenue because they were not allowed under the Constitution, and at that time the Constitution was the Articles of Confederation. All right, to impose duties or taxes, but they had a right to trade amongst themselves. All right, but they didn't have international rights because they were already subject to international duties imposed upon them by Great Britain. Let's prove it. A tariff is a tax imposed by the government of the country or by a supranational union on imports or exports of goods. Besides being a source of revenue for the government, import duties can also be a form of regulations of foreign trade. You hear that? And policies that taxes foreign products to encourage or safeguard domestic industry. Let's move forward. History. We're not concerned about ancient Greece because we're not in Greece. We're here in North America. All right? All that's irrelevant. So the only one we can make references to the origin of tariff here in North America is based off the connection that we have with Great Britain, because under 16.1-28, it clearly says rights stated under the charge of Great Britain saved from repeal. An act to incorporate trustees of religious society for property held in corporations in place thereof. And the property that's being concerned here is the land. All right? Is the land. If you don't own the land, there's no way you can trade on the land. All right? With anybody. That's the reason why those who colonized were not allowed to trade foreign and international trade as a result of them being colonists. All right? I'm gonna show you that in this case. Watch how powerful this case is. Not just this case, Bedell versus Biddle, but as well as Dred Scott versus Sandford. Great Britain, in regards to the origin of tariff, originated in the 14th century under Edward III, 1312 to 1377, who took interventionist measures such as banning the import of woolen cloths and attempt to develop local woolen cloth manufacturing. Beginning in 1489, Henry VII took action such as increasing export duties on raw wool. This carried on to the Tudor monarchs, especially Henry VIII and Elizabeth I. That's where you get it passed on to the House of Stuarts, all right, who set up shop here in North America. All right, do y'all see the connection? Let's move further. So we know that was the monarchs ruling who imposed duties on the colonists here. All right, they imposed these duties on the colonists here. How? Let's prove it. Taxation on the colonists, because the tariff is a tax. Todd, I hope you're listening. Taxation of the Colonies Act of 1778 was an act of Parliament of Great Britain, way before the Tariff Act of 1789 from the United States that allowed them to raise revenue, Why? Because they could not do international trade to raise revenue. The only way they can raise it was to pass an unconstitutional act, which in the eyes of the law of that land was null and void, because all debts contracted prior to the adoption of that constitution or any statute enacted as a result of the creation of that statute is null and void. All right? The Taxation of the Colonies Act of 1778 was an act of the Parliament of Great Britain. That means Ireland, England, and Scotland. All right? Ireland, England, and Scotland. All right? That declared Parliament would not impose a duty tax or assessment for the raising of revenue in any of the colonies of the British America or British West Indies. The act passed during the American Revolutionary War was an attempt by Parliament to end the war, but succeeded on the early points of dispute. By this time, America already made their mind up to break away. All right? As a result of these tariffs, the Sugar Act, the Stamp Act, the Townsend Act, all right? All these acts were tariffs put on the colonies, all right? But yet, they're going to take it upon themselves to violate the very law that gave them the authority to do what they do by surrendering the power of the king at that particular time to that of the Articles of Confederation. This was a violation of law. Let's get to it. Dilemma versus Vidal. Point 132. Council contends that upon the ratification of the treaty and upon the secession of Puerto Rico to the United States, that territory become a part of the United States within the meaning of the general grant of taxing power of the federal government, subject to the limitations contained in that provision, which require all duties, imposts, and excises to be uniform throughout the United States. All right? Throughout the United States. And discussing that effect of the treaty, I shall not repeat the historical arguments so fully and elaborately presented by the government in the discussion of Goes cases. I shall rather attempt, after going over the terms of the treaty, to analyze the pertinent provisions of the Constitution of the United States, with a view of determining what was the real meaning intended by the framers of the Constitution to be given to the words United States used in that connotation. Before we do that, let's look up the Articles of Confederation. Now we know in Article 6 of the United States Constitution of 1789, it says that all debts engaged with the colony at that particular time is the supreme law of the land. All judges, senators, officers, I don't care who you are, but subject to that, to those contracts as adopted under the Articles of Confederation, which are still valid in this present day. All right? So we're talking about tariffs for the United States under the Constitution of the United States of 1789 because they passed the first Tariff Act in the United States in 1789. All right? To raise revenue in lieu of foreign or international trade. All right? Foreign or international trade. So let's see what it say here. Because since the Articles of Federation are still valid, right? They're still valid. Article 6. No state without the consent of the United States and Congress assembled shall send any embassy to or receive any embassy from or enter into any conference, agreement, alliance, or treaty with any king, prince, or state, nor shall any person holding any office of profit or trust under the United States or any of them, except any present eminent office or title of any kind, whatever, from any king, prince, or foreign state, nor shall the United States and Congress assemble or any of them grant any titles of nobility. Why? Because they were not a nation. They were just a committee of men who had an idea about their ideal of a government. All right? A grand corporation. They had an operation of the ideal of creating this grand corporation. All right? A grand empire that they assume to have. It's an idea. This case is going to validate that, right? grand corporation. This is also qualified in the United States Supreme Court, Chisholm versus Georgia. We're gonna refer to that as well. All right. It also says here, no two or more states. We ain't talking about those under Article 4, Article 4 of the Constitution, Section 3, Clause 1, that allow new admissions to the state, such as the other states outside of the 13. It says here, no two or more states shall enter into a treaty, confederation, or alliance, whatever, between them without the consent of the United States and Congress assembled, specifying accurately the purpose for which the same is to be entered into and how long it should continue. We're talking about the Articles of Confederation. We know the Articles of Confederation is no different than the United States government that you have here, because the style name of the United States government should be called the United States of America. All right? No state shall lay, you hear that? No state. That means any state within the Union under the Articles of Confederation, now called the United States, shall lay any imposed duty which may interfere with any stipulation in treaties entered into by the United States and Congress assembled, or with any king, prince, or state, in pursuance of any treaties already proposed by Congress to the courts of France and Spain. Did y'all hear that? Did y'all hear that? Somebody then stepped out there. Why? Let's prove it. That's the Articles of Confederation. Now let's go to Dilemma versus Bedell. All right, so we're here now. Reduced to a legal proposition, the denial of the power which has been exercised is being exercised by a de facto officer known as the president, and by Congress, which is the House of Representatives and the Senate. And the new possessions amount to this. All right? This is a 1901. It amounts to this. Ceded territory becomes, by this act, a cession, an integral part of the United States, to which the Constitution of its own force at once applies, placing its people, its product, and its ports on an immediately equality with ours, conferring upon them all the rights, privileges, and immunities enjoyed under the Constitution by the people, the product, and the ports of the several states. You're talking about people, y'all. All right, dealing with international trade, foreign trade, not domestic trade, but international trade. All right, which the Articles of Confederation clearly said you could not do. All right, they said you could not do. Article 6 of the Constitution, as we read, says you could not impose any duties, contracts that were already created with any king, prince from France or Spain. And we know the kings of France were the king of Spain, because we're not talking about Frankish kings under the Frankish alliance made with the Scottish, Frankish, and every other colonists who came here on behalf of the English inheritance or birthright. I'm going to prove it. Right here. All right. Moreover, the limitation of the Constitution applied there as here. Let me go back. I got to read this because I don't want y'all to miss this. This is dealing with taxation, tariff, dealing with foreign trade, right? International trade. In regards to the parties in this case, which was the sugar company and the Port of New York. The Port of New York at this time with the sugar company were under the authority of the United States government, which goes back to the argument involving the port, which was taxing, which didn't have the authority to tax as established under the Articles of Confederation, which the court ruled in lieu of that perspective. All right? The court ruled in lieu of that perspective. All right. It clearly says, reduced to a legal proposition, the denial of the power which has been exercised is being exercised by the president and by Congress, and this new possessions amount to this. Ceded territories become by the act of cession an integral part of the United States, to which the Constitution, its own force, at once applies, placing its people, its product, and its ports on an immediate equality with ours, and conferring upon them all the rights, privileges, and immunities enjoyed under the Constitution by the people, the products and the ports of the several states, ports in general. Moreover, the limitations of the Constitution apply there as here, requiring the same tariffs, taxes, duties, imposed, and excises to be collected. And the same Anglo-Saxon system of a trial by jury is to be used. Did you hear that? We talking about United States Supreme Court in 1901, talking about the jury in which the jury is deciding this case in 1901. They're making reference to the Anglo-Saxon trial by jury system in regards to the subject matter, because you can't have subject matter jurisdiction if you don't have personam jurisdiction. All right, over the parties involved in this case, which is two corporations created by way of incorporating by way of what we call statute. The people become at once our people, citizens of the United States. Our ports become their ports, and our markets their markets. They are free to come here or to sell their product here, while our taxes and our laws, however unsuitable, must go there. Going back to the taxation of the colonies, back to that which was the revenue of the crown, which, as we know, under the Title 46, 3-1-1 and 1-2, in lieu of the land being allodial, it's called free income and soakage. That makes reference to what we call the king's revenue, the king's tariff. Oh, y'all don't hear me. No, y'all don't hear me. Y'all don't hear me. The corporation sold and the corporation is two different entities. Let me qualify that by Chisholm versus Georgia before I continue with DeLimber versus Bedell. Let's go to Chisholm versus Georgia. Chisholm versus Georgia. United States Supreme Court. Thus, it appears that in England, even in the case of a private debt contracted by the king in his own person, and these cases, Chisholm versus Georgia, as well as United States versus O'Keefe, deals with the right of a subject of the king to petition, which is a right under the royal prerogative as established in Ward versus Kingdom by Chief Justice of the Supreme Court of New Jersey, Chief Justice Vanderbilt, that said that it can be suit can be issued at the auspices of a private citizen and invoke the prerogatives of the crown, i.e., the royal prerogatives, which is the powers protected by the Legislative Council, i.e., King and Parliament, under the judicial review of the King's Bench, which, according to Villain versus Harris, that the legislative branch of New Jersey was powerless to separate the power of the King's Bench, which was validated not just in the 1776 Constitution of New Jersey, not just the 1844 Constitution of New Jersey, and which 1978 Constitution of the United States was model, but also the 1947 Constitution, which was created under the revamp in Rutgers University by the governor Alfred Driscoll, who nominated the first Chief Justice of the Supreme Court, Chief Justice Vanderbilt, in this case that was being revealed under what we call Villain versus Harris, okay, which I'll show you in a second for all those who don't believe me. It says, thus it appears that England, even in the case of a private debt contracted by the king in his own person, all right, there is no remedy but by petition. Petition or through petition a certification, which is informally called a writ of circular tort. All right, a writ of circular tort. If the debt contracted be avoidably for the public uses of the government, it is at least doubtful whether the remedy will lie. If it will remain afterwards in the power of Parliament to provide for it or not among the current supplies of the year. All right, let's go here. What was it? Oh yeah, I know where I want to go. Here we go. Chisholm versus Georgia. It says the only law concerning corporations to which I can see the least reference is to be had is the common law of England on that subject. I need not repeat the observation I made in respect to the operation of that law in this country. The word corporation in its largest sense has a more extensive meaning than people generally are aware of. Anybody politics, sole or aggregate. You hear that? Sole or aggregate. All right. Whether its power be restricted or transcended, is in this sense a corporation. The king, accordingly, in England is called a corporation, i.e., corporation sole. So, also by a very respectful author, is the parliament itself. In this extensive sense, not only each state singly, but even the United States may without impropriety be termed a corporation. I have therefore, in contradiction to this large indefinite term, used the term subordinate corporations, meaning to refer to such only as alone capable of the slightest application for the purpose of the objection, whose creation and whose powers are limited by law, i.e., statute. The difference between such corporations in the several states in the Union as relative to the general government are very obvious in the following particulars. First, a corporation is a mere creature of the king or of parliament, very rarely of the latter, most usually of the former only. It owes its existence in its name and its laws, except such laws as are necessarily incident to all corporations merely as such, to the authority which creates it. A state does not owe its origin to the government of the United States. It's in the highest or in any of its branches. It was in existence before it. It derived its authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people. All right? Of the people. A corporation can do no act but what is subject to the revision either of a court of justice or some other authority within the government. Did you hear that? A state is altogether exempt from the jurisdiction of the courts of the United States or from, once again, a state is altogether exempt from the jurisdiction of the courts of the United States or from any other exterior authority unless it is special instance where the general government has power derived from its constitution itself. So as we know, under the Articles of Confederation, which consists of the 13 colonies, now 15 colonies now called states, the power surrendered under the 13 colonies, i.e., now called states, was the power that rightfully belonged to king and parliament. And we know king created the corporations, i.e., because as a result of his prerogatives, his royal prerogatives, as we just read, king creates corporations, or the parliament create them, and it said very rarely is of the latter, and most likely of the former. All right? Okay. So you see it here in Chisholm versus Georgia, and we know that these prerogatives of the king go all the way back to those kings deriving from the Plantagenet crown. How we know? Because in this same case, just like it did in Johnson versus Jones versus Freedman, it mentioned Edward IV and Edward and Henry VIII of the York and Lancaster branch in regards to de facto and de jure officers in lieu of the English throne, which represented by what we call the crown. Okay, 437. Blackstone, once again, mentioned in this case, just as it mentioned in Jones, uh, uh, Jones versus Freeman, Blackstone made reference to Edward IV and the usurpers, the Lancaster descendants from the House of Lancaster, and which Henry VIII was the senator. All right, it's mentioned right here in this case. 437, you say? What's it? 437, 427. Give me 1 second, everyone. Yeah, it must be 437. Crown of England. Oh, here we go. I'm look right over it. Wow, I'm blind like a bat. So in Chittenden versus Georgia, uh, they recognize the difference between a sole corporation and a corporation and a corporation. And we know that all corporations were created by the king. All right. And they actually mention the king right here. Whatever that remedy was strictly applicable or not, still I apprehend there was no other. The only remedy in case like that before the court by which by any possibility a suit could be maintained against the Crown of England or could be at any period from which the common law as enforced in America could be derived as believed is that which is called a petition of right. You hear that? It is stated indeed that until the time of Edward I, the king might have been sued in all actions as a common person, and so authorities are cited for that position, though it is even there stated as a doubt. But the same authority adds, but now none can have an action against the king, but one shall be put to sue to him by petition. Why? Because the king cannot be sued in his own court. All right, a king cannot be sued in his own court. Why? Because the courts that were established here under the corporation now called America was the courts that were established here by the king, known as the King Bench, which according to Ward versus Welling versus Harris, let's go there before we go back to LaBelle versus Beaton. That's it. I think that's it. D. Lima versus Bidwell. Ward versus Welling versus Harris. Taj receipts. Taj, these are receipts I'm showing the people. These are receipts I'm showing the people. Just like they said in Jones versus Freeman that the United States adopted the Anglo-Saxon jury by trial system. All right? The Anglo-Saxon jury by trial system. It says here, the New Jersey First Constitution adopted July 2nd, 1776, terminated its status as an English colony and being in sovereign existence as a state. Article 22 of that Constitution continued the common law of England in force. That Constitution was replaced by the Constitution of 1844, modeled largely in structure and content of the Constitution of the United States. By Article 10, paragraph 11, it too continued to enforce the common law of England as well as the existing courts of law and equity, i.e., chancery. So also the current Constitution of 1947 by Article 11, Section 4, Paragraph 3, continuing to enforce all existing laws. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, invested with all powers of the King's bench, which the legislature was powerless to cut down or to assign to the courts. This principle was especially strong in fields of prerogative writs, of which circulator was the most frequently sought. Did you hear that? The most frequently sought, along all the others. All right? As they said in Jones versus Freeman, and Oklahoma case in regards to not Jones versus Freeman, but Libido versus Bidwell, what's it called? What's that case? Dilemma versus Bidwell, it clearly shows you in that case that in regards to the government pertaining to Congress, the House and Senate, and it just strictly means House and Senate. That's what it said. It didn't say nothing about the House of Representatives. It says House and Senate. It says that in regards to avoiding the chaos in lieu of the office being held under the tenure of the officer, that the example or the standard that was set forth in lieu of judicial review of that office was based upon the Anglo-Saxon design. All right? The Anglo-Saxon design, which is based off the Anglo-Saxon system that was created by what we call a trial by jury. So if this Anglo-Saxon judiciary system that was created going back to the Anglo-Saxon system by trial by jury, then we must go back to the origin where that was established. Okay, so let's do that, because it said that in Jones, as said it in not Jones, it said it in LaBelle, Dilemma versus Bidwell. Let's just prove it. Everybody see that? All right. Anglo-Saxon system trial by jury. All right. And they're referring to what the United States is practicing. All right. But we know the Anglo-Saxon trial by jury by the King's bench under the authority of the king was not based off a corporation, but a corporation soul, which is a natural person. But according to this case, how they deem the United States is based upon their interpretation as the incorporation of the United States by their charter, i.e. their constitution, which is verified in section 0.154, which we'll go to now. In lieu of the Anglo-Saxon jury by trial system that America has adopted and that all territories ceded to the United States are subject to in regards to the tariffs placed upon them, which goes back to the laws governing England, which all land was ceded to under the English Parliament as verified by the Treaty of Paris, which in this case, the Treaty of Paris was a treaty made with Spain in the 18th century, which is constitutional to that one made in 1763 as a result of Spain succeeding all the territory to France, all right, which was succeeded to Great Britain in 1763 of the Treaty of Paris, all right, which the United States took under the Louisiana Purchase of 1787, all right. It says here, under the Lima versus Bidwell, a 1901 case under the United States Supreme Court, to repeat, the United States of America, which Chief Justice Marshall in Dixon versus the United States said is the true name of the grand corporation which American people have formed, and the charter will, I trust, long remain in full force and vigor, is a body of policies of which the state alone are integral constituent part. They only, as the same Chief Justice said in Heaven versus Ilsley, being the members of the American Confederacy, and this governing entity exercise sovereignty over the American Empire, our great republic, which is composed of the states and territories. And in the broadest sense, if he does not mean by this territories unorganized than over that too. All right. So as we can see, the United States is known as that great corporation. All right. We know the great corporation is subject to the charter, as you just said, which is its constitution that was created in 1789, which gave its ability to create tariff laws, which is contradictory to Article 6 of the Article of Confederation, which was the constitution at the time before they became the United States, i.e. states. All right. And within that, they were subject to the Anglo-Saxon system that was governed at that time, even though under the de facto monarchs at that time under King George III. All right? Under King George III. Why? Because it just said they were governed under the Anglo-Saxon system to a trial by jury. Everybody have a right to a trial by jury, right? Amongst your own peers. Isn't that the case? Yes, it is. So let's go to the origin of the Anglo-Saxon peers, because we know the tariffs absent of that going back to ancient Greece, originated from Great Britain under Edward III, who was descendant of the Plantagenet crown, going to Godfrey V kind of Anjou. All right? And we know that they were the inheritors or the establishers of the Anglo-Saxon tribes going back to a trial by jury. All right? As established in this case, Dilemma versus Bidwell, a United States case. Where's it at? Where is that at? 132. Right here. So we know that the United States of America, which is the great grand empire, all right, American empire or the great corporation, as a result of the charter given to them by way of the secession of the Crown's territory, which was under the British government, known as the British Empire. That's why America termed American Empire, because you got the authority from the British Empire. And as they said, and what was that case? Chisholm versus Georgia, they were subordinate to the king because the king, the one that gave you the charter. All right. And you're tried by the king's courts. As stated here, Anglo system of trial by jury was to be used in this modern day. So let's go to the origin of the Anglo-Saxon jury by trial system that was established and that still functions in this modern day, governing this case, Dilemma versus Bedell, that deal with the territory dealing with the port of New Jersey in regards to the tariffs that were placed upon United States under the, governing the port at that particular time as a result of the conflicts going back to New Jersey and New York port campaigns that originated in the time of the Revolutionary War. All right, from 1707 to 1778 at the time of the Articles of Confederation. All right, let's get to it. Anglo-Saxons trial by jury. Where does that originate from? I know it's a lot, y'all. 1901 case dealing with taxation on in lieu of international trade or foreign trade on imposts and duties, which we know under the English system was imposed upon the British, the colonies, all right? Which in 1789 they established their own tariffs to raise revenue for themselves, all right? All right, it's either create that statute or tax the colonies themselves, all right? Because they only had a right to domestic trade, not international trade, because there were tariffs being put on them by the crown. So it says the history of the trial by jury in England. It didn't say Scotland. It didn't say Ireland. It said England. All right, and it just said in the case Libidell versus what was it? Dilemma versus Bidwell, that they adopted the Anglo system trial by jury, not the British system trial by jury, but the Anglo system trial by jury. So we're reviewing the Anglo system trial by jury which existed before the British trial by jury and the American trial by jury. It says here the history of the trial by jury in England is influential because many English and later British colonies adopted the English common law system, which trial by jury plays an important part. And we know in the Smith versus Alabama, all states within the Union adopted the common law of England, which must be read in light of the English history. So if you're going to adopt the common law of England and read in light of the English history, then you must go back to Anglo-Saxon origin of the trial by jury in Anglo-Saxon England, which we'll go to right now. Here it is. The English king, Ethelred Unready, issued legal code of wantage, which states the 12 leading thegns, minor nobles of each wapentake, wapentake means county, all right, a small district, were required to swear that they would investigate crimes without bias. These juries differ from the present day kind by being self-informing. Instead of getting information through a trial, the jurors were required to investigate the case themselves. Later Middle Ages. In the 12th century, Henry II, son of Godfrey, fifth Count of Anjou, which we descend down from, took major steps in developing the jury system. Henry set up a system to resolve land disputes. You hear that? Land disputes. The matter dealing with what was it? Del Limma versus Bidwell was dealing with land dispute because in order for you to be able to tariff, you must have control of the land, which under the secession of Puerto Rico, the United States became controller of the land by usurping the power of the crown as proven by king and parliament, because we know that king and parliament was taxing their butt when they were the colonies, all right? When they were the colonies. Let's move forward. So we see it going all the way from Ethelred the Unready, the son of our Jesus Christ, King Edward the Peaceful, which I'm the reincarnation of, had that Anglo-Saxon trial by jury passed down all the way up to the 12th century by Henry II's son, Henry II, son of Godfrey, the fifth Count of Anjou, going back to the Treaty of Westminster of 1153, when William the Conqueror, who invaded through the Norman invasion, which we'll see that case echo in Dred Scott versus Sandford. All right? It's going to be echoed in Dred Scott versus Sandford. As well as Henry II, as well as King John. All right? No free man should be captive or imprisoned or deceased of his freehold or of his liberties or of his free customs or be outlawed or exiled or in any way destroyed, nor will we proceed against him by force, proceed against him by arm, but by lawful judgment of his peers or by the law of the land. All right. So you see why you can go in these courts of law. You got a bench hearing and now the trial by jury, because you don't know the origin of the trial by jury and who it pertains to. Peers by those who where the trial by jury originated from. Now for anyone else, because if the trial by jury didn't originate against the peers where it originated from, then you are a foreigner and you're subject to the mercy of the court, known as a bill of Middlesex. All right. Let's move forward. Let's move forward. All right. So we understand that in Dilemma versus Bidwell, it said that the Anglo-Saxon jury trial was applied in cases involving tariffs, right? And we know tariffs is the ability to be able to do international trade as well as raise revenue based off imposts and duties, all right? We know the origin of tariffs from the origin of England goes back to Edward III, all right? Who descended down from King John Henry II, as well as Ethelred the Unready, because Edward the Confessor was a son of Ethelred the Unready, and his great-grandmother was Margaret of Scotland, who was married to Henry I, who was the son of William the Conqueror, who invaded England and brought in these feudal tenders when you have what you now call fee and simple. All right, contrast to Intel, because we know Intel is crown land. I'm bad. Okay, let's go back to the tariff. tariff. In Great Britain, you see tariffs originated all the way from Edward III until Henry VIII, until Elizabeth I, and all of them were a part of the Lancaster branch, which is the cadet branch of the Plantagenet crown. They are what they call usurpers. All right? They're usurpers, as stated in Jones versus Freeman. They're usurpers of the English crown. All right? Let's find out who else is usurpers. All right? Since we see that and what was it? Dilemma versus Bidwell, they mentioned the Anglo-Saxon trial by jury, you know what I'm saying, which automatically must have existed at the time of Edward I and his descendants, because it exists now. All right, so we did Great Britain. Let's go to the United States. The United States tariff laws. We know what a tariff is, a tax. Before the new Constitution took effect in 1788, the Congress could not levy taxes, it sold land, or beg money from the states. As you read in Article 6 of the Articles of Confederation, you could not collect imposts or duties. So the United States is beside themselves. That's why in that case, Dilemma Mindell, the plaintiffs won the case because the port could not tax, it could not collect tariffs as a result of the original contacts engaged in under the Articles of Confederation under the United States Constitution, Article 6. All right? Tariff in the United States. Before the United States Constitution took effect in 1788, the Congress could not levy taxes. It sold land or beg money from the states. The new national government needed revenue and decided to depend upon a tax on imports with the tariffs of 1789. The policy of the United States before 1860 was low tariffs for revenue only, since duties continued to fund national government. All right, so this is how they funded their national government, by either creating tariffs or by taxing the colonies. All right, by taxing the colonies. They tax themselves, but yet you arguing the taxes that the crown was doing upon you. Let's get into it. All right, so that Dilemma versus Bedell was a result of tariffs or taxation that the United States government was doing on trade and commerce, i.e. international trade and commerce, with a company that was transporting sugar, all right, which was a commodity at that particular time, all right? And they said in that case that the United States didn't have the authority for tariffs. They didn't have the authority to collect taxes on imposts and duties. All right? You'll see it in this case. Let's find out why, though. All right? Let's find out why. Excuse me. Going back to Wikipedia, the case in regards to the tariffs that the United States government was put on imposts and duties in lieu of international trade that involved the ports, New York and New Jersey, was unconstitutional. All right, it was unconstitutional. As we see here, Port of New York City, which is the Port of New Jersey, because New York and New Jersey is a metropolitan. All right, it's a metropolitan. So let's go to Port of New Jersey. in the history of the port of New Jersey. Very important. We know the French controlled the western part of North America. We know the French colony started with the Frankish king, what was his name? Francis the First. All right, which is from the house of Valios and Acclamain, which was a branch of the Capitan or the House of Capet, which is down from the Capitan dynasty, who were warned with the Plantagenet. War with the Plantagenet dynasty, which resulted in the Treaty of, I think, the Treaty of Paris of 1295. All right, Treaty of 1295. All right, but as we can see, the history involving the ports of New Jersey and New York goes back to the early history, which it states that the usury was originally the territory of the Lenape, so-called Native American. We know under the public land trust doctrine, they were just simply occupants of the land. They had no right to the land because their deeds were null and void. All right. A seasonal migration people who would relocate summer encampments along its shores and use its waterways for transport of fishing. Many of the tidal salt marshes supported vast oyster banks that remained a major source of food for the region until the end of the 19th century. All right. All that falls under the public land trust doctrine, which is stipulated in Martin versus Waddell and Johnson versus McIntosh, which Dred Scott is going to make reference to. Okay. Going to make reference to in lieu of successions. All right. The first recorded European visit was by the Frankish discoverer Giovanni de Verrazzano, who anchored the Narrow in 1524. He was worked on behalf of the of France. All right. The Kingdom of France. All right. Let's just make sure, qualify it. And we know this Kingdom of France was the House of Capet. Right here. Giovanni di Verrazzano was in service to King Francis I of France, the same one who colonized the western part of North America. All right? So we're not dealing with the western part of North America. We're dealing with the eastern part of North America, all right, along the Atlantic seacoast and what we call the areas known as Port of New York and New Jersey. And the origin and history involving the Port of New Jersey goes back to Francis I, all right, which was the first recorder in lieu of discovery. And we know discovery was done on behalf of the House of Tudors, all right, which we are proving right here. It says here, European colonization began with Henry Hudson, and Henry Hudson navigated on behalf of Henry VIII. Let's prove it. For the sake of time, we're gonna move forward. All right. Anyhow, early European colonies began with Henry Hudson, exploration of the region with the establishment of New Amsterdam. All right. New Amsterdam was surrendered to Charles II at the restoration of the crown on the Treaty of Westminster of 1673. All right. Anglo and Dutch War. At the tip of it says that Henry Hudson's 1609 exploration of the region was the establishment of New Amsterdam, the capital of the Dutch province of New Netherlands, at the tip of Manhattan. The British colonial area saw a concentrated effort to expand the port, all right, and the triangular trade. We're talking about the Atlantic slave trade, y'all, between Europe, Africa, and North America, with a concentration of wharves along the mouth of the East River. Did you hear that? All right, along the East River. After the Battle of Brooklyn, the British controlled the harbor for the duration of the American Revolutionary War, and prison ships housed the thousands of walls-bound. This gets into what we call the New Jersey and New York campaign, or what we call the Philadelphia campaign. All right, because under the Commander General Howe, on behalf of the British George Washington on behalf of the Continental Army, there was a bunch of conflicts involving this port. Okay, involving this port, which was heavy in the slave trade. You hear that? Was heavy in the slave trade, which involved this port, and which Dred Scott was a participant. Why? Because he was deemed property. All right, and we're going to show you Dred Scott has a Scottish last name or surname, which denotes to Scottish descendants or Scottish heirs. And we know Scottish got their independence in 1295 by the Plantagenet King Edward I. All right. So we must understand that the administration functioned at that time under the de facto rulers sitting under the authority of the crown, which was in charge of the intel estate on behalf of heirs. And as a result of Dred Scott's ignorance, he could not receive right of suffrage, right? Because he had no precedence to base his suffrage off. All right, which I'm giving you remedy. All right, because suffrage can only become on behalf of questioning your leaders. All right, questioning your leaders as required by as it's stated in what was it, Ward versus Keenan, at the act of a private citizen. It also says it in what was the case, Jones versus Freedman. All right, by a private citizen. Let's move forward. So we see the Port of New Jersey or the Port of New York, which was the matter concerned in the case involving tariffs or taxation on imposed duties that the United States imposed upon the corporation, the company, what was it called? Del Lima, which was the sugar company, in regards to it, or assumed to be a foreign endeavor, which was not the case because under the Treaty of Paris, Puerto Rico was ceded to the United States. So therefore, the tariff could not apply. All right? As provided under the Articles of Confederation, because that authority to tariff and impose duty was that which created under the parliaments that existed at that time, which was under the authority of what we call Great Britain, or the British Empire, what we call British America. We must understand these precedents. Let's move forward. Let's see where I want to go. So we know the origin of the Port of New Jersey and Port of New York in regards to the case at hand, Dilemma versus Bidwell, in regards to tariffs. And it said in that case that in regards to judicial review of the tariffs in regards to the discrepancies that were at hand, it said that it should have been reviewed as adopted in that modern administration from the House and Senate as it was in the days of our Anglo-Saxon jurors, which was that which was prescribed by what we call a trial by jury. All right, a trial by jury. All right, let's go back into what we call the origin of the Port of New Jersey and New York in regards to the days that it was formed at the time of what we call the Revolutionary War, which is called the New York campaign and what they call the Jersey campaign. Let's review that real quick before we get into what we call the Dred Scott case. It's going to be a long one, y'all, so forgive me. New York campaign, New York and New Jersey campaign. All right. During the American Revolutionary War under the Articles of Confederation to the First and Second Continental Congress from 1777 to 1778. So everybody pull that up. Give me a couple minutes. I'll be with you in a second. All right. In a second. I'm coming, y'all. Here I come. All right. Real quick. New York, New Jersey campaign. The belligerents. Commanders, George Washington. On the British side, Sir William Hope, on behalf of King George III, who was the monarch at that particular time. Keep in mind, the tariffs involving the colonies in 1778 by King George III, who was willing to agree to relieve them of some relief on the tariffs that were imposed upon them by the crown. But at this time, they were well off into their ideal government that it was, they crossed the threshold. So it says here, involving Port of New Jersey and Port of New York at establishing Del Mar Sugar Company versus the port, which is in question. All right, this is the origin of that port. Goes back to the New York and New Jersey campaign, and 1776 in the winter months of 1777, which was a series of American Revolutionary War battles for control of the port of New York. You hear that? And the state of New Jersey. Once again, a series of American Revolutionary War battles for control of the port of New York and the state of New Jersey. Not the state of New York, but the state of New Jersey, fought between the British forces under General Sir William Howe and the Continental Army under General George Washington. Howe was successful in driving Washington out of New York, but overextended his reach and to New Jersey, and extended to New York and New Jersey campaign in January 1777, with only a few outposts in New York City under the British control. That was Perth Amboy and New Brunswick. The British held New York Harbor for the rest of the Revolutionary War, using its bases for expedition against other targets. All right, those who got time, read it up on your own. We also go to the Philadelphia campaign. Philadelphia campaign, contrast to the, or in parallel to the New York and New Jersey campaign involving the port, the location of New Jersey, Maryland, Delaware, involving the same two belligerents, George Washington and Sir William Howe. All right, George Washington and Sir William Howe. The Philadelphia campaign was a British effort in the American Revolutionary War to gain control of Philadelphia, the Revolutionary era capital, where the Second Continental Congress convened and signed the Declaration of Independence, which formalized and escalated the war. You hear? So all this was control of the port of New Jersey, which was the British Empire defending the territory that was under the crown, which was being rebelled against by the 13 colonies who made up the Articles of Confederation, and it was all about taxation, right? Because the two things about their constitution, their government, was the uniformity on taxes and the uniformity on what we call equality. If there was no uniformity on taxation, there was no uniformity on quality, because that's what they came up with their slogan: no taxation without representation. You know, representation denotes to that which is the House of Representatives, and the House of Representatives was the one who created the so-called tariff of 1789, not the Senate. The House of Representatives. You don't believe me? Let's see. Everybody see this? Tariff. United States, before the new Constitution took effect, 1788, the Congress could not levy taxes. It sold land and begged money from the states. The new national government needed revenue and decided, depending upon the tax on imports, but the tariffs of 1789. Hey, Queen. 1789. All right. So the Tariffs Act of 1789 gave them the ability to create or collect what we call revenue. Revenue. All right, but they, according to Articles of Confederation, they was not supposed to collect revenue, because the revenue that they were collecting all belonged to the king, right? As it's stated in Dilemma versus Bedell. All right, it stated that in Dilemma versus Bedell. Let's read it again. I'm gonna highlight it for you. Reduced to a legal proposition, the denial of the power which has been exercised and is being exercised by the president and by Congress, and this new possession, i.e. secession, amounts to this: ceded territory becomes by this act of cession an integral part of the United States, to which the Constitution of its own force at once applies, places its people, its product, and its ports on an immediate equality with others. All right. Equality was the uniformity that they wanted, as well as uniformity on taxes. We know taxes is the tariff. So the only way the United States, as we said in tariffs, can create revenue was the sale of land, right? Or to create that Tariff Act of 1789, all right, which was contrary to the legislative act that was governing them at that time under the authority of that Constitution. All right, it says here, moreover, the limitation and Constitution applies there as here, requiring the same tax duties imposed and exercised and to be collected in the same Anglo-Saxon system of a trial by jury to be used. All right, so let's bring this home. Let's bring this home. Make sure I ain't forgetting nothing. Step by step. I don't see how you can be ignorant to these facts. I'm taking you step by step. Like, what sense does it mean to do 15-minute videos when you could just do the same thing as you could do in a 15-minute video? Just pause it, go back, do the research, then come back and restart. All right? I can't help it if your comprehension level is not able to comprehend on the level that mine is, as well as those who are able to keep up. The Articles consciously established a weak central government under the Articles of Confederation, which is what the United States government is still under, affording it only those powers the former colonies have recognized as belonging to king and parliament under the King's Royal Regalia, as we see it in the United States Dairy Company versus Carter. All right, a 1933 case in Virginia, a Supreme Court case. All right, it says that the only powers they recognized that they surrendered to the Articles of Confederation was the powers belonging to the king and parliament. And the king and parliament functioned over what? Functioned off of what? World prerogatives. What world prerogatives? The world prerogatives that we see in what was it? Jones versus Freeman. Let's show you. It says the rule in all probability domestic violence as a result of chaos would ensue if a de jure de facto legislature could not be convened. So even though there's de facto officers and de jure officers sitting in these seats in lieu of a tender, the auspices of how they sit in lieu of that tenure is based off the interpretation of the legislator, all right, in which under this new administration, Duquesne questioned as a result of the royal prerogatives of the crown missing, because as we've seen in Chisholm versus Georgia and United States versus O'Keefe, that you have a right to petition, you have a right to put a petitioner right when you are injured by any officer in lieu of their pledge to be de jure, but in essence acting de facto, all right? And we know that they're acting de facto, as we just read in the Articles of Confederation, because the power of the legislator that was in fusion of power that the king had as king and parliament under the Royal Regalia was usurped by way of the as a result of the separation of that fusion of power to what we call separate branches: the executive, legislative, and judicial branch. All right. Very, 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 very powerful information. So it says here in Jones versus Freeman that in all probability, domestic violence, meaning not international or foreign violence, but domestic at home, as a result of chaos. The opposite of chaos is what? What's the opposite of chaos? Justice, order, truth would ensue if a de jure or de facto legislature could not be convened. Anglo-Saxon civilization afforded a rule of law Rule of law is established by a legislative branch, right? And the Anglo-Saxon legislative branch was governed by the fusion of power as exemplified by king and parliament under the jure regalia of the king, as under the public trust as established under the Articles of Confederation, because it said no public trust is required, no religious test is required on the public trust. The separation of powers does not require a religious test, but yet they got this power, which does not involve God, because the church involves God. All right? So that in all probability, domestic violence as a result of chaos would ensure if the juror or de facto legislator, the one who makes a law, cannot be convened. Anglo-Saxon civilizations afforded a rule of law means rex nunquam mortier, which means that the king must never die. And to avoid such chaos and violence. The only way you can avoid such chaos in regards to the office in lieu of the understanding of if it's de jure or de facto, you must understand king and parliament. All right? You must understand king and parliament, which we see here in this case law that they adopted. But do you see a king? No. So therefore, there's chaos. Let's move forward. Legislative council under the king and parliament. This is just we are visiting what was already taught in the past lecture before I close with Dred Scott. The history of legislative council is the legislative or one of the legislative chambers of a nation, right? Nation, subnational division, province, or state. We know New Jersey was ruled under the New Jersey Provincial Council under the province of New Jersey. That was that existed from 1664 until it was surrendered to the crown in 1702, which remained perpetual, indefinite. All right. The crown rules under the King's Royal Regalia, contrasts to that which was surrendered under the Articles of Confederation to a legislative council, which is just assembly of men that just create positive law, which enslaves the English people as established in Somerset and Somerset versus Stuart, which you'll see in the reference in the Dred Scott case, which I'll close on. All right. It says in the United States, a legislative council contrasts to that of a nation, subnation, subnational division, or province or state is a council which has a different connotation that was mentioned in the former. And it means a council which a legislature which supervises a non-partisan support staff. All right. And you can tell the difference by way of understanding the history of a legislative council versus a council. All right. Because state council and United States council are ran by commissions or commissioners. All right. It says in the British Empire, the authority under the legislative council has been constituted and has varied. Some under royal prerogatives, others by acts of parliament, and some by commissions and royal instruction, particularly unicameral or the upper house, and in bicameral legislature, where traditionally many members were appointed by the governors rather than elected, were given the designation of legislative council. We know that under the state government, the highest active officer is the governor, whereas in the federal government, the highest active officer is the president, which we know this is where the chaos coming from, because under the colonies who joined the Union under the Articles of Confederation, the highest authority under the states that joined the Confederation were governors. So where did the executive office and the power of the executive office come from, which contradicts the very power that the Constitution has established under Article 1 and Article 2? Which is separation of power, not a fusion of government, because there was a fusion of government in which the House of Representatives and the Senate was governed by, as we see under the United States codes, as ran by the Vice President and the House Senate or the House Speaker, which is Mike Johnson. Then we know that that's all under the cabinet of what we call the President, which operates under what we call the Electoral College. All right, under their parliamentary procedures, which is separate from the parliamentary procedures created by the legislature. All right. So we see under the history of legislative council, under, as we see, as established in United States Fidelity versus Carter, that the king's royal prerogatives are still active in 1933. All right, let's quote that real quick before we move on. I think I still have it here. Yes. United States Fidelity, in this case to Virginia, 1933. Prefaces. Common law, prerogatives of the king. We know the prerogatives of the king are the legislative council and in lieu of what we call a fusion of government, which was here in New Jersey in 1776 under the New Jersey Provincial Council, which at that time was perpetual. Perpetual. It said from the very early times, the common law of England gave or rather recognized the king's assertion. Hold that thought 1 second. Greetings.
Yo, what up?
What's up, brother? I'm doing a lecture. Everything all right?
Yeah, I'm good. I'm just letting you know I'm coming to Jersey tomorrow.
Oh, okay, all right. What's the occasion?
I'm just here for a memorial service. I'm gonna be there for a day, and I'm leaving out. I was gonna see where you was at.
Yeah.
So I might check you. I'll call you when I get to town.
All right, that's what's up. I'll talk to you then.
All right.
One. All right, that's my brother Lateef Jefferson. All right. So as we can see, as established in this case, United States Fidelity Company versus Carter in 1933, as established by the Supreme Court of Virginia. I think it's Supreme Court of New Jersey. Let me just make sure. Yeah, Supreme Court of Virginia, that the king prerogative in 1933 are still active. All right? Are still active. So, in lieu of that, we see that the king's bench and the king's government is so active in this formal government, then we must understand what government is assuming to be the king's government, because we know that the citizens of this government, based off the people who make up the government, under the characteristics of those who are of the government, are those who are classified as free white person. All right, and free white person, under the terminology as established by the Naturalization Act of 1790, has nothing to do with genetics or ethnicity. Okay, and that is the first test in regards to approving to be a part of some nation, genetic and ethnicity. All right, they failed to establish the genetic ethnicity test as a result of the usurpation of the genetic and ethnicity identity of the people who were there prior to them being allowed to get there by their de facto charters given to them by de facto officers, as established in, as we've seen, Jones versus Freeman. All right. So in order for them to bring them into question, do what we call court warranty under the royal prerogatives of the crown, it must be done by a private citizen. All right. And a private citizen cannot be a state citizen or a United States citizen, and they can't be a citizen that's by the Naturalization Act as a result of the status that was designed by the Naturalization Act, which did not include Negro, Black, Colored, and Ethiopian, and all the other identities that you want to place upon people of English descent. All right, so let's qualify. Dred Scott gonna qualify because he's gonna let you know those who were subject to that Dred Scott decision were of English descent. They just didn't know it as a result of the status that they were under, that was created by those sitting on the English throne and acting as English monarchs, which usurped the throne at the time of the War of Roses, that originated with the conflict of the House and the Yorks and the Lancasters, as established by the precedents that you see here set before you by I, your king, as a result of being descendants of the house that was there prior to that confusion. All right, so let's qualify. We know under the Treaty of Westminster of 1153, known as the Treaty of Wallingford, the Treaty of Wallingford was when the Duke of Normandy or the Duchess of Normandy was surrendered to Henry II when Sandford reign was over. This was the agreement that William the Conqueror made with Matilda. Matilda was married to Godfrey V, Count of Anjou, and she was born with her brother Stefan, which resulted in what they call the anarchy, or what they call the white ship. All right, you must understand this story to understand what's going on as a result of the citizenship question on who classifies as a citizen. Because we know under the Settlement Act of 1701, all those who were allowed to come here by way of colonization, which consists of the 13 colonies, was done by way of the monarchs under the House of Tudors, under the Lancaster branch, descended down from Henry Elizabeth I, Henry the Eighth, and Henry the Seventh, the founder of the House of Tudors, which was a result of marriage of those who were the jure kings of the Lancaster branch, which were cadet branches of the Plantagenet crown. All right, which, as you can see in Jones versus Freeman, that William Blackstone, a Venerian professional at Oxford University, clearly said that those de facto officers, even though they hold that office, were usurpers of the crown as a result of the ignorance of primogeniture and inheritance of the estate, in lieu of the office that the estate was protected under crown entail, was preserved for that office held by the king. You don't believe me? Let's prove it. Let's go to Dred Scott versus Sandford. (1856) case by Chief Justice Taylor. Look how much they knew about ourselves, and we didn't know. And they de facto judges, because it wasn't the king's bench, because the review by the United States Supreme Court in regards to the case involving Dred Scott, the Supreme Court was de facto in nature as well, because it originated from the Judiciary Act as a result of the judiciary that was enacted by your presidents, which was head of the executive office, not the legislative office, which was under the power of Parliament. Because we know that before you had the United States government, you had the states government, and the most superior government out of the states government, which was the government governed by the crown, which was the Province of New Jersey from 1776. All right, under the monarch called Queen Anne, which apparently Todd think that the inheritance that she was the trustee over was for them, which I have proven beyond a reasonable doubt. Why? Let's see what Dred Scott had to say about this. Because he said Nefertiti were descendants of the Scottish kings who the Moors were descendants of. That's what he said. In that same video that he said that the English descendants contrast to the Scottish descendants were those who came out the caves, which I proved was wrong as a result of them showing that not only were there Anglo-Saxon, but they were a darker complexion, started with Astrakhan, which we qualify with the case of our Enway versus Hassan, contrast to the citizenship that was classified with Caucasians or free white persons in regards to those who make up this government here in North America and in present day, which people of the dark complexion under the, for the lack of a better term, Negro, black, colored, or dark skinned, etc. Without the origin going back to the genetic or ethnicity, you lack standing. All right, which in the way Hassan says that dark skinned Anglo-Saxons are the preferable identity for those who originated on the European Iberian Peninsula, also known as Berber, as established by the United States versus Bagat Singh Ding, which was heard in the same case. All right, so let's see what they say in Dred Scott. We're going to start from right here. Now let's see how much Dred Scott, Chief Justice Taney knew about Dred Scott versus what I'm telling you. I know more than Chief Justice Taney know. All right, which I'm telling you in this present day that you don't want to believe me, and Chief Justice Kennedy is telling you back in 1856, this is where your remedy is, because they letting you know that if a Negro black slapped a Scottish or English descendant, which they were sitting on the English throne, pursuing to be English descendants, de facto English descendant, because there are no English people here today. So they say, until we came upon the scene, the English Third Temple Church of England. All right. So it says here in that same case involving Dred Scott, and we know Dred Scott is a surname that's spelled in English. And we know that Dred Scott and the name Scott is of English descent, of Scottish descent. And we know that Scottish were subject to the English as a result of the Scottish independence going back to 1295, going back to Edward I. All right, of the Plantagenet crown. The power of the master over his slave has been extremely different in different countries. The state of slavery is of such a nature that it's inapplicable of being introduced on any reason, moral or political, only by positive law, as established by some in Somerset versus Stewart, but only by only by positive law, which preserves its force long after the reason, occasion, and time itself from which it was created are erased from memory, time out of mind. It is so odious that nothing can be suffered to support it but positive law. Same thing they said in Somerset versus Stewart. That there is a difference in a system of the state which recognize and which do not recognize the institution of slavery cannot be disguised. Constitutional law, punitive law, police, domestic economy, industrial pursuit, and amusement, the modes of thinking and of belief of the population of respective communities all show the profound influence exerted upon societies by this singular arrangement. This influence was discovered in the Federal Convention and the deliberation on the plan of the Constitution. Mr. Madison observes that the states were divided into different interests, not by their difference of size, but by other different interests, not by their difference of size, but by others. Circumstances that most material of which resulted from climate, but principally from the effects of their having or not having slaves. These two causes occur in forming the great division of interest in the United States. Going back to the New Jersey and New York campaign and all involving the ports. You know, the ports goes back to the transatlantic slave trade. You know what I'm saying? And we know that British were involved in the slave trade because we know that the ports that were involved not only involved the ports in New York and New Jersey, but also ports that in our Perth Amboy, which was under the authority of the Crown. Because when you go back to the Philadelphia campaign and the New York and New Jersey campaign involving the ports of New York as establishing a Del Mar Sugar Company versus the Port of New York. We know all those interests that are in this present day matters that we're subject to today all stem from that direct influence of the transatlantic slave trade. All referenced here in this Dred Scott case. All right, let's qualify it. The question being raised with the opinion of Lord Mansfield, therefore, is not in respect to the incongruity of the two systems, but whether slavery was absolutely contrary to the law of England. You hear that? To the law of England. For if it was so clearly, the American law could not operate there. So I clearly show you under the public trust doctrine, Martin versus Waddell, and what's it called? What was the other case? Martin versus Waddell and Johnson versus McIntosh, which Dred Scott is going to reference in regards to this estate that it's been left in limbo. All right. He says that in this case, but whether slavery was absolutely contrary to the laws of England, for if it was so clearly, the American law could not operate there. All right. And we know America was founded off slavery. All right. Historical research ascertained that at the date of the conquest, did you hear that? At the date of the conquest, the rural population of England, ain't talking about the conquest going to discovery here in North America. They said the conquest of the rural population of England were generally in a severe condition and under various names denoting denoting slight variances in conditions. They were sold with the land like cattle and were a part of its living money. Did you hear that? Did you hear that? So we have an 1856 case dealing with Dred Scott, which at this time he was considered money. All right, he was considered as money, i.e., personal property that was used as a medium of exchange and in lieu of commerce, whether it was domestic or foreign. All right, whether it was domestic or foreign. And this is in the 18th century. All right, and their origin of what was going on in the 18th to the 16th century all got their origin going back to the conquest. How we know that? Let's see what Dred Scott said. Historical research ascertains that at the date of the Norman conquest, the rural population of England were generally in a severe condition. And under various names denoting slight variances in condition, they were sold with the land like cattle as were a part of its living money. Traces of its existence of African slaves are to be found in the early chronicles. Parliament in the time of Richard II and also Henry VIII refused to adopt a general law of emancipation. Why? Because they were all practicing slavery of the English people. Acts of emancipation by the last named monarch and by Elizabeth are preserved. Did you hear that? African slave trade had been carried on under the unbounded protection of the crown for nearly 2 centuries when the case of Somerset versus Stewart was heard, and no motion for its suppression had ever been submitted to Parliament while it was forced upon and maintained an unwilling colony by the Parliament of the Crown of England at the moment. 15,000 Negro slaves were then living in that island. You hear that? So this was subject to what we call insular cases, where they have been introduced under the counsel of the most illustrious jurists of the realm, and such slaves have been publicly sold for near a century in the markets of London. In the northern part of the kingdom of Great Britain, it didn't say England, it didn't say Ireland, it didn't say Scotland, which were separate parliaments prior to the Union in 1707. It said the kingdom of Great Britain. So we know that these were dealing with Scottish kings sitting on the English throne, enslaving the English people, now known as Negro, Black, Colored, Ethiopian, classified or reclassified as Native American, which was mere occupants of the land, which had a better right than Dred Scott. All right? There existed a class of from 30,000 to 40,000 persons, of whom the Parliament said in 1755, under the King George III, all right, that they were many colliers, coal heavers, and salters are in a state of slavery or bondage, bound to the colliers and salt workers, where they work for life, transferable with the colliers and salt works when their original masters had no use for them. And whereas the emancipating or setting free colliers, coal heavers, and salters in Scotland. Did you hear that? In Scotland. Now, Todd's going to say that the Moors are descended of those of the Scotland who descended from Nefertiti. So guess who they talking about? They're talking about you, are the slaves. Not us, the English people. Why? Because those who were the Moors, which you say were descendants of Scotland, which we know were subject to England under the Plantagenet King Edward I, through the Scottish the Scottish independence of 1295, and at that time you was took an allegiance with the Frankish kings under the Order Alliance as a result of y'all both warring with the English kings. So how could the English kings come out the cave, let alone be slaves, if the Scottish kings, which you claim to be sending down, were the ones not only practicing slavery, but were in coercion with the Moors through the Order Alliance, going all the way back to what was it said? I don't want to quote the wrong thing. We're gonna move forward, but matter of fact, we're gonna prove it because the Tarik goes back to the tax on imports and duties at that time when slaves were the commodity, right? When slaves were the commodity. All right, let's move forward. Okay, so it says, who are now in a state of servitude gradually and upon the reasonable conditions will be that by means of increasing the numbers of colliers, cohebers, and salters to the great benefit of the public without doing any injury to the present masters, and will remove the reproach of allowing such a state of servitude to exist in a free country. And again in 1799, they declared that many callers and cohevers still continue in a state of bondage. No statute from the conquest. You hear that? No statute from the conquest, i.e., the Norman conquest, till the 15th of George III have been passed upon the subject of personal slavery, which Dred Scott was. These facts have led the most eminent civilian. These facts have led the most eminent civilian of England to question the accuracy of this judgment and to insinuate that in this judgment the offense of the employer jurisdiction by private authority was committed by the eminent magistrate who pronounced it. This sentence is distinguishable from those cited from French courts in this, that their positive prohibitions existed against slavery, and the right of freedom was conferred on the immigrants slaves by positive law, whereas here the consequence of slavery merely that is a public policy, were founded to be contrary to the laws of slavery. The case of slaves, Grace 2G, blah, blah, blah. I'm going to read that when we move forward. Let's start here. The decision of Lord Mansfield was that so high an act of dominion as the master exercised over the slave and sending him abroad for sale could not be exercised in England under American law and contrary to the spirit of their own. The decision of Lord Stowell is that the authority of the English laws terminated when the slave departed from England. Once again, the decision of Lord Stowell is that the authority of the English laws terminated when the slave departed from England. That the laws of England were not imported into Antigua with the slave upon her return, and that the colonial forum had no warrant for applying a foreign code to dissolve relations which had existed between persons belonging to that Islam, and which were legal according to their own system. There is no distinguishable difference between the case before us and that determined by the Admiralties of Great Britain. Let's go a little further. The Congress shall have power to dispose of and make all needful rules, regulations respecting the territory or other property belonging to the United States. We're talking about secession. And noting in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. It is conceded in the decision of this court that Congress may secure the rights of the United States in the public domain. We're talking about the public trust, provided for the sale or lease of any part of its established or any part of it, and establish the validity of the title of the purchases, and may organize territorial government with power of the legislation. But the recognition of a plenary power in Congress to dispose of the public domain or to organize the government over it does not apply a corresponding authority to determine the internal polity or to adjust the domestic relations of the persons who may lawfully inhabit the territory in which it is situated. A supreme power to make needful rules respectfully the public domain, in a similar power of framing laws to operate upon persons and things with the territory limits where it lies are distinguished by the broad lines of demarcation in American history. This court has assisted us to determine them in what we call Johnson versus McIntyre. 595. Before we go to Johnson versus McIntyre, because we know that Johnson versus McIntyre is the case decided by the United States, contrasts with that, as well as Martin versus Waddell. Johnson versus Martin versus Waddell and Johnson versus McIntyre are two cases that deal with the public trust doctrine. Okay, but since Dred Scott versus Sandford referred to Johnson versus McIntyre that deal with the public trust doctrine, and it denotes to the point 595 to 543. We're going to go to Martin versus Waddell before we go to that point, which in closing. All right, Martin versus Waddell. We know the ports of New York, New Jersey, involving the marshes is all public trust land. All right, this is what these cases are about. Martin versus Waddell and Johnson versus McIntosh, which was cited in Dred Scott versus Sandford, right here. Let's see where I want to go. Right here. In the argument of this case, the counsel, make sure y'all all see this. Oh, this, I know this is gonna be a second. Give me a second. We know that all the territory referencing Dred Scott versus Sandford, dealing with the Norman conquest from King George to King George III, was territory that was sent to the Plantagenet ground, King Henry II, to the Treaty of Westminster, 1153, as it just said in Dred Scott versus Sandford. All right, that's why it all involved the public trust. Dred Scott Sandford clearly says that. All right, and Dred Scott versus Sandford, Kelly stated, let's go back to it real quick. Actually spoke about the public trust doctrine. All right. And the public trust doctrine is governed under Johnson versus McIntosh and Martin versus Waddell. So let's go back to Martin versus Waddell. It says the argument of this case, the counsel on part of the defendant referred to the case of Warren versus Matthew. As reported in the 6th Mode 17, where it is said, every subject of common right may fish with lawful net in the navigational rivers as well as in the sea, and the king grant cannot bar them thereof, and this case has been much relied on in the argument of the case now before this court. But this report of the case in 6th Mode 17 is clearly a mistake. It is the only case to be found which the broad proposition here state is recognized, that the king grants cannot bar the subject of a common right of fishing. And as the report of the same, the case as stated is that one claims solemn piscarium in the river X by a grant from the crown, and not Chief Justice said that subjects have the right to fish in all navigational rivers as he has to fish in the sea. And a court warrant ought to be granted to try the title to this grantee and the validity of his grant. You hear that? Our petitioner right. Lord not here, no doubt meant to speak of the prima facie evidence right of the subject. For if he intended to say that no such exclusive right could be given by the grant from the king, it would be absurd to issue a court warrant, i.e. orders to show cause, to try the title and validity of the grant, if by no means possibility a valid grant could be made. At all events, it is very certain that the King's Bench in the case of Carter versus Milcott did not recognize the doctrine of Warren versus Matthew as report in 6th Mode 73, and under this circumstance, it is entitled to no way a decision in the case now before this court. Why? Because as we know, the King's Bench was vested in the Supreme Court of New Jersey as established in Waddell Billin versus Harris. All right, which the legislature was power to separate. All right, powerless to separate. Where it is, it says here. In the case of Johnson versus McIntosh, This court said that according to the theory of the British Constitution, all vacant lands are vested in the crown. Did you hear that? Did you hear that? So not just Dred Scott said it, but Martin versus Waddell said it. All right. According to the theory of the British Constitution, all vacant lands are vested in the crown as representing the nation, and the exclusive power to grant them is admitted to reside in the crown as a branch of the royal prerogative, i.e., King of Parliament, and this principle is as fully recognized in America as in Great Britain. All the lands we hold were originally granted by the crown. Our whole country has been granted, and the grants purport to convey the soul as well as the right of dominion to the grantee. Here is the absolute ownership and recognized as being in the crown, and to be granted by the crown as the source of all titles to this extent, as well as to land covered by water as to dry land. Otherwise, no title could be acquired to land under the water. Did you hear that? Let's go to Johnson versus McIntosh, which was referred to in Johnson versus McIntosh in the Dred Scott case on point 595. Let's go to point 595. In closing, it is supposed all you judges, Supreme Court judges, district court judges, appellate judges on the federal level as well as on the state, you better look out. I'm coming for you. Johnson and Graham's Leslie versus McIntosh, 1823, dealing with the public trust doctrine, which was referenced in Dred Scott versus Sandford in regards to the inheritance that was left in the trust, all right, for the English heirs and successors. How we know it, it says here, it is supposed to be the principle of universal law that if an inhabited country be discovered by a number of individuals who acknowledge no connection with and owe no allegiance to any government whatever, the country becomes the property of the discoverer. All right. We know discovery goes back to Henry VIII, and we know the right of conquest goes back to Henry VIII as a result of the usurpation of the offices as de facto when they were at the time of the War of the Roses, which we see that was referenced in Jones versus Freedom. All right. Jones versus Freedom. All right. The title of the whole land is in the whole society. It is to be divided and parceled out according to the will of society expressed by the whole body or by that organ which is authorized by the whole to express it. So the crown has the ability and authority to grant charges and for land to be parceled out. Not the United States, not the colonies, not Scotland, not Ireland, England. The king and parliament in England, which is perpetual, is indefinite, and which is, still exists in its present government. If discovery be made and the possession of the country be taken under the authority of the existing government, which is acknowledged by the immigrant, it is supposed to be equally well settled that discovery is made for the whole nation, that the country becomes a part of the nation, that the vacant soil is to be disposed of by that organ of the government which has the constitutional power to dispose of the national domain by that organ in which all vacant territory is vested in by law. All right? Vested in by law, and that takes us here in closing. Says too quiet. Queen of Petoris. by Edward the First, 1275 to 1307, as qualified in the revised statute. Alienation of freehold. Statutes quem petores terrarum. From after March 18th, 1795, any freeholder, which means if you hold a fee simple, fee indefeasible, or life estate, may give or sell or alien the real estate whereof he is, or at any time to be seized, in fee simple or any part thereof at his pleasure, and such donee, purchaser, or alienee shall hold the same free of any tenure or service to the donor, seller, or alienator. So you must hold it in the same likeness as it was a statute, as it was established under Edward the First. All right, let's go ahead. 3-15. Whenever any conveyance, will, or instrument writing shall hereafter be made, whereby any grantee divides or other person shall become seized in law or in equity of such estate in real estate as under the statute of the 13th of Edward the First, called the Statutes of Entail, the donors conditionally bust, would have been held at any state in fee of any type of character, such conveyance, will, or instrument shall vest in the state in fee and simple, and such grantee divides the or other person. All right, and closing. This is where I want to go. Presidents. Taj, if you're saying you're descendants of Scottish kings, then you better show me how your rights are validated as a result of disposition by way of statute. All right, because inheritance or estates that are inalienable in lieu of what we call entail transferred by what we call a statute of dispensation. All right, which you see here. Saving the rights under charges granted by Great Britain. Being Section 12 an act incorporate the trustees of religious society. We know under the public trust doctrine, the king is head of the public trust as corporation sold. 1,875, which was saved from repeal. This section invested property held on the charges of incorporation granted by Great Britain and corporation created in place thereof. So every corporation in America, as established in what they say, what was that? Dilemma versus Bidwell, part of the American corporation or the Great American Empire, is subordinate as a result of its judiciary review that's governed by the Anglo-Saxon system, which was governed by the law that put the judiciary system of trial by jury in place, which was that of the laws as established in what we've seen in Jones versus Freedom. I mean, part itself. What was it? Lebel. I mean, Dilemma versus Bidwell talks about the Anglo-Saxon. No, yeah. Dilemma versus Bidwell talks about the Anglo-Saxon trial by jury, which is governed judiciary known as the King's Bench, pursuant to that which was established through his legislation, i.e. King and Parliament, which we see in what we see in the court case in Jones versus Freedom. All right. And in Jones versus Freedom, it clearly says that the legislative system that was used in regards to the law, and we know law is created by the legislator, was based off that of the king, because king never died pursuant to the legal lexum rex nunquam mortier. Once again, rex nunquam mortier. All right, which is the remedy for the chaos that we are in now. All right, so I know I had y'all for a minute, but this is to qualify once and for all that some of our great influencers are the worst teachers. Once again, some of the great influencers who have that gift of speech that are able to attract people are the worst patterns to follow. All right? There's a saying, he who writes your books sets your timeline. You know what I'm saying? So if your timeline is set by he who writes your books, and it doesn't reference to the timeline that the courts recognize going back to the time immemorial where you were not, then guess what? Your time never existed. All right. So with that, me, your king, reincarnation of King Edgar the Peaceful, and all the martyrs and saints who died that are written in the New Minister's Liber Vitae, i.e. the Book of Life, are waiting for your name to be written in that Liber Vitae Book of Life, which is under the auspices of what we call King Edgar the Peaceful, who now represents the image of Christ or the Christ-like or the personification of Christ through the incarnation or personification or the incorporation of that divine entity known as the Sovereign King. So with that, I say peace.